Elections will now come to order. The clerk will call the roll.
Chair Click.
Here.
Rep Cortez.
Here.
Rep Busey.
Here.
Rep Burrows.
Here.
Rep Kane.
Here.
Rep Fierro.
Here.
Rep Israel.
Here.
Rep Middleton.
Here.
And Rep Swanson.
Here.
A quorum is present. Good morning, everyone. Before we take up bills on the agenda today, I'd like to vote out several bills. While we're doing that, if there's anyone here who would like to testify on any of the bills that we'll be hearing today, you must register on the electronic witness affirmation kiosks in the hall before you testify and indicate which bill you would like to testify on. If you've not done so yet, you have a few minutes while we vote out some bills to register. Additionally, if you have any documents that you would like distributed to members, please give them to Teresa before you begin your testimony, and she'll distribute them for you. The chair lays out House Bill 1888 as pending business. Members, this is Representative Bonin's bill relating to temporary branch polling places. Are there any questions? Representative Burrows moves that House Bill 1888 be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Representative Click.
Aye.
Rep Cortez.
No.
Rep Busey.
No.
Rep Burrows.
Aye.
Rep Kane.
Aye.
Rep Fierro.
No.
Rep Israel.
No.
Rep Middleton.
Aye.
Rep Swanson.
Aye. 5-4. I'm sorry. 5-4.
There being 5 ayes and 4 nays, the motion prevails. House Bill 362 by Israel. The chair lays out House Bill 362 as pending business and offers a complete committee substitute. Members, this is Representative Israel's bill relating to voting equipment fund. The substitute clarifies that only certified equipment with a paper trail qualifies. It also directs the Secretary of State and the counties to study how best to replenish the fund. Are there any questions? Is there any objection to the adoption of the committee substitute? Hearing none, the substitute is adopted without objection. Representative Busey moves that House Bill 362 as substituted be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Rep Click.
Aye.
Rep Cortez.
Yes.
Rep Busey.
Yes.
Rep Burrows.
Aye.
Rep Kane.
Aye.
Rep Fierro.
Aye.
Rep Israel.
Aye.
Rep Middleton.
Aye.
Rep Swanson.
Nay. 8-1. 8-1.
There being 8 ayes and 1 nays, the motion prevails. The chair lays out House Bill 529 as pending business. Members, this is Representative Miller's bill related to the renewal of an appointment as a volunteer deputy registrar. Are there any questions? Representative Cortez moves that House Bill 529 be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Representative Click.
Aye.
Representative Cortez.
Aye.
Representative Busey. Representative Burrows.
Aye.
Representative Kane.
Aye.
Representative Fierro.
Aye.
Representative Israel.
Aye.
Representative Middleton.
Aye.
Representative Swanson.
Aye. 9-0.
There being 9 ayes and 0 nays, the motion prevails. The chair lays out House Bill 933 as pending business and offers a complete committee substitute. Members, this is Representative Busey's bill relating to posting election information on the Secretary of State's and other counties' website. The substitute made clarifying changes and added that the Secretary of State can receive gifts and grants to fulfill the measure. Are there any questions? Is there any objection to the adoption of the committee substitute? Hearing none, the substitute is adopted without objection. Representative Middleton moves that HB 933 as substituted be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Representative Click.
Aye.
Representative Cortez?
Yes.
Representative Busey? Representative Burrows?
Aye.
Representative Kane?
Aye.
Representative Fierro?
Aye.
Representative Israel?
Aye.
Representative Middleton?
Aye.
Representative Swanson?
Aye.
There being 9 ayes and 0 nays, the motion prevails. The chair lays out House Bill 1459 as pending business and offers a complete committee substitute. Members, this is Representative Gonzalez's bill related to the appointment of early ballot boards. The substitute addresses concerns where parties do not submit lists and to address tie votes, among others. Are there any questions? Is there any objection to the adoption of the committee substitute? Hearing none, the substitute is adopted without objection. Representative Israel moves that House Bill 1459 as substituted be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Representative Click?
Aye.
Representative Cortez?
Yes.
Representative Busey?
Aye.
Representative Burrows?
Aye.
Representative Kane?
No.
Representative Fierro?
Aye.
Representative Israel?
Aye.
Representative Middleton?
Nay.
Representative Swanson?
Nay. 6 to 3.
There being 6 ayes and 3 nays, the motion prevails. The chair lays out House Bill 2075 as pending business and offers a complete committee substitute. Members, this is Representative Niave's bill relating to surnames on the ballot. The substitute clarifies the original intent of the bill. Are there any questions? Is there any objection to the adoption of the committee substitute? Hearing none, the substitute is adopted without objection. Representative Swanson moves that HB 2075, as substituted, be reported favorably to the full House with a recommendation that it do pass and be printed and sent to the local and consent calendar. The clerk will call the roll.
Representative Click?
Aye.
Representative Cortez?
Yes.
Representative Busey?
Yes.
Representative Burrows?
Aye.
Representative Kane?
Aye.
Representative Fierro?
Aye.
Representative Israel?
Aye.
Representative Middleton?
Aye.
Representative Swanson?
Aye. 9-0.
There being 9 ayes and 0 nays, the motion prevails. The chair lays out House Bill 2910 as pending business. Members, this is my bill relating to the confidentiality of personal information. Are there any questions? Sure. Representative Fierro moves that House Bill 2910 be reported favorably to the full House with a recommendation that it do pass and be printed and sent to the local and consent calendar. The clerk will call the roll.
Representative Click?
Aye.
Representative Cortez?
Yes.
Representative Busey?
Yes.
Representative Burrows?
Aye.
Representative Kane?
Aye.
Representative Fierro?
Aye.
Representative Israel?
Aye.
Representative Middleton?
Aye.
Representative Swanson?
Aye.
There being 9 ayes and 0 nays, the motion prevails. The chair lays out House Bill 3044 as pending business. Representative Israel offers a complete committee substitute. Members, this is my bill relating to political expenditures made by a corporation. The substitute clarifies that only 501c3s can receive PAC match contributions. Are there any questions? Is there any objection to the adoption of the committee substitute? Hearing none, the substitute is adopted without objection. Representative Cortez moves that House Bill 3044 as substitute be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Representative Click?
Aye.
Representative Cortez?
Yes.
Representative Busey?
Aye.
Representative Burrows?
Aye. Representative
Kane?
Aye.
Representative Fierro?
Aye.
Representative Israel?
Aye.
Representative Middleton?
Aye.
Representative Swanson?
Aye.
There being 9 ayes and 0 nays, the motion prevails. The chair lays out House Bill 3233 as pending business. Representative Israel offers a complete committee substitute. Members, this is my bill relating to the Judicial Campaign Fairness Act. The committee substitute clarifies what contributions are governed by individual guidelines and which are governed by PAC guidelines. It removes the joint campaign event disclosure requirement. Are there any questions? Representative Burrows moves that House Bill. Sorry. Okay. I'm sorry, members. Let me back up. Are there any objections to adopting the committee substitute? Hearing none, the committee substitute is adopted. Representative Burrows moves that House Bill 3233 as substituted be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Representative Click?
Aye.
Representative Cortez?
Yes.
Representative Busey?
Aye.
Representative Burrows?
Aye.
Representative Kane?
Aye.
Representative Fierro?
Aye.
Representative Israel?
Aye.
Representative Middleton?
Aye.
Representative Swanson?
There being 9 ayes and 0 nays, the motion prevails. The chair lays out House Bill 3580 as pending business. Members, this is my bill relating to political advertising, contribution, and expenditure provisions. Are there any questions?
Can I go to LNC as
Our Representative Kane moves that House Bill 3580 be reported favorably to the full House with a recommendation that it do pass and be printed and sent to the local and consent calendar. The clerk will call the roll.
Representative Click?
Aye.
Representative Cortez?
Yes.
Representative Busey?
Yes.
Representative Burrows?
Aye.
Representative Kane?
Aye.
Representative Fierro?
Aye.
Representative Israel?
well? Aye.
Representative Middleton?
Aye.
Representative Swanson?
Aye.
They're playing over here.
There being 9 ayes and 0 nays, the motion prevails. The chair lays out House Bill 4447 as pending business and offers a complete committee substitute. Members, this is Representative Kane's bill relating to early voting rosters. The substitute corrects a drafting error and requires the information be provided on a publicly accessible website or bulletin board. Are there any questions? Is there any objection to the adoption of the committee substitute? Hearing none, the substitute is adopted without objection. Representative Burrows moves that House Bill 4447 as substituted be reported favorably to the full House with a recommendation that it do pass and be printed and sent to the local and consent calendar. The clerk will call the roll.
Representative Click?
Aye.
Representative Cortez? I can come back to you. Representative Busey?
Aye.
Representative Burrows?
Aye.
Representative Kane?
Aye.
Representative Fierro?
Aye.
Representative Israel?
Aye.
Representative Middleton?
Aye.
Representative Swanson?
Aye.
There being 9 ayes and 0 nays, the motion prevails. Those are the bills for today, and we can start on new business.
I think her bill is 3250. It is. She's, oh, sorry.
The chair lays out House Bill 3250 and recognizes Representative Allen to explain the bill.
Here. Thank you. Madam Chair and members, currently, each county party is the agent for holding county primary elections in Texas, and the county chair administers the primary election. Candidacies filing fees and state general revenue are used to pay for the cost of an election. The Secretary of State currently pays for ballot printing and ballot equipment programming. If the county chair contracts with the county clerk or election administrator to run the primary, then the Secretary of State reimburses the county directly for the cost of the election. If there are excess fees after the primary, they are returned to the state comptroller. For a chair in a small county, it is difficult for a political party to open a bank account. In many cases, when the county chair contracts with the county clerk or election administrator to run the primary, there is no money coming in to the chair, which means there is no filing fees and no bills to pay. In such cases, the chair will not need to open a bank account. But if it becomes necessary, it is much easier for the state party to be the fiscal agent to accept single filing fee checks or pay bills. Under current law, in small counties, the state chair and the Secretary of State allows the state party to have absolute control over financial transactions related to the primary election. HB 3250 sets into statute current practices that occur when the state chair and the Secretary of State agree to serve as the fiscal agent for a small county to accept and expend funds for the primary. The bill creates a framework to track agreements in writing and to ensure records are filed for transactions related to primary elections. It allows the county to forego opening bank accounts for only one or two transactions. Basically, that is the bill. Madam Chair, I believe I have a witness, and I reserve the right to close.
Members, are there any questions for Representative Allen? Okay. The chair calls Glenn Maxey to testify.
Thank you, Madam Chair. Glenn Maxey, Texas Democratic Party, in support of House Bill 3250. I serve as the primary director of the Texas Democratic Party, and in that role, deal with these interactions all the time. Under current law, I'm doing everything that this bill does. There's just no paperwork. And all I'm trying to do here, or what we're suggesting to do here, is that if I become the fiscal agent for a county, that we actually sign sort of a contract to do so, that it's in writing, and then I file that with the Secretary of State. Right now, I'll simply notify the Secretary of State that I have a filing fee check in the primary account of the state on behalf of a county. It's all done by word of mouth and emails, and so I believe that if I get hit by a truck, I'd like the next person that does this kind of work to have a little framework of how to do these agreements.
Members, any questions? Are these situations where there's not currently a county chair?
It often happens where there's not a county chair and they contract with the county, so the county's paying all the bills, the state's paying for the ballots. No money's coming into the chair, and then at the very last minute, somebody walks in and says, I want to run for JP. And the county chair says, oh, I need to open up a primary banking account. It is almost impossible for small counties to do bank accounts today. It's difficult for a large county because political parties in Texas do not fit any of the banking regulations. They're not a nonprofit, they're not a business, they're not an individual, and so the bank, if they try to open up an account at a national bank, they get the response of, I need your articles of incorporation, I need your last meetings minutes, and all those kinds of things that don't fit a county party. So it is almost impossible to open up a bank account anymore. It takes sometimes 6 to 8 weeks to get it done, or they have to go to a bigger city and find some bank that will just look the other way on the regulations. Therefore, this is just the stopgap when there's a transaction that has to happen for the primary to happen, and there's no bank account. The state party accepts the money and pays whatever bill or remits the money to the Secretary of State.
Okay, thank you. Members, any questions? Representative Fierro.
Mr. Maxey, welcome. Does this make the party liable for all outstanding debts if they become the fiscal? They're becoming the fiscal agent, aren't they?
Well, the parties, whether it's the county party or the state party, this is the primary fund. So there's nothing that can be done going into the account other than filing fees and general revenue from the Secretary of State. There could be contributions, but I've never heard of anybody giving money to a primary fund. And then the bills that are paid are only the election workers those kinds of activities that are all audited by the Secretary of State. So it's a very limited use of the money, and so there's no liability outside of what we already are liable for.
Members, any other questions? Thank you. Okay, members, we have Christina Atkins with the Texas Secretary of State's office here. Do we want to bring her up? Anybody have questions that they have for her? Okay, thank you. Is there anyone else wishing to testify on, for, or against House Bill 3250? The chair recognizes Representative Allen to close.
Thank you, Madam Chair. I close.
If there's no objections, House Bill 3250 will be left pending.
Madam Chair,
I'm sorry?
can I say something?
Yes.
Thank you, Madam Chairman. I just wanted to wish Representative Alma Allen a happy birthday.
Thank you very much.
If there are no objections, House Bill 3250 will be left pending. The chair hears no objections. House Bill 3250 is left pending without objection.
Thank you.
The chair lays out House Bill 1406 and recognizes Representative Dean to explain his bill.
Thank you, Madam Chair. Morning, members. Reckham over here, Chairman Burrows. Let's go tonight. Members, in 4 different places of our election code dealing with confirmation notice, registrars are directed to Section 15.051, which begins by stating if the registrar has reason to believe, instead of clearly stipulating what constitutes reason to believe. Each of the aforementioned references are clearly intended to fall into the understanding of reason to believe, as they make direct reference to 15.051. However, the vague language in the section itself is not helpful to our registrars or administrators who carry out a critically important responsibility for our counties. HB 1406 simply clarifies that the 4 sections, 13.146, 14.023, 16.0921, and 15.0681D constitute notice under 15.051, which I mentioned is stipulated in each of the sections, but not in itself 15.015. I think we'd all agree that a lot of parts of our code are due for a clarification overhaul. However, until that time, HB 1406 is just one small piece of that. With that, Madam Chair, I'm happy to entertain questions, and I ask for the right to reserve.
Members, any questions? Okay. Thank you, and we'll start calling our witnesses. The chair calls Alan Vera. Please state your name, who you represent, and your position on the measure.
Alan Vera, Chairman, Harris County Republican Party Ballot Security Committee, testifying in support of HB 1406. I have personally lived the nightmare this bill addresses. On July 30th of last year, I filed a residency challenge with the voter registrar, challenging people registering to vote at commercial post office boxes. There were 4,027 names challenged. What followed looked like an episode of F-Troop because the voter registrar did not know what to do, handled it wrongly, and then the county attorney had to step in and say that my challenge was improper. Then the Secretary of State overruled him, and so they changed the reason. On December 1st of last year, I bought the brand new voter registration roll and ran it against the same addresses. This time I had 5,762 people registered at mailboxes, etc. The problem is getting worse. Voters now know how to circumvent the prohibition against registering to vote at a P.O. box. They use the street address of the UPS store and use the P.O. box as their apartment number. The problem is growing. It's a rebirth of an old practice called packing the district. Voters who don't actually live in the district holding an election but register at a street address which appears to be in the district are swaying the results and consequences for voters who actually live in the district. Voters who won't ever have to pay for a bond are passing the burden of that bond onto the voters who actually live in the district. Can it be serious? Yes. The last Houston mayoral election runoff was won by 4,000 votes. There were 4,027 people in the district improperly registered. Is that a direct cause and effect? I don't know. It's a real problem. The bill makes it clear the voter registrar must take the correct action when informed of the conditions that merit a confirmation notice. Please pass it out of committee.
Members, any questions? Thank you. The chair calls Ed Johnson.
Chair. Ed Johnson, here testifying for myself. I'm for the bill. I will, do I need to say the bill number 1406? This is a great fix to our problem. I have been in the voter registration department, director of voter registration Harris County for many years, and the end result in the election code is if you go through Alan Vera's scenario where they didn't take action right away, he would end up filing a challenge and you would actually have a hearing on every one of those cases, and the end result of the hearing would be that you would send them a confirmation notice to confirm where they live, which is what this bill does. So all roads lead to the final result in challenging somebody. As you send them a confirmation notice, this does not take them off the voter roll. The worst case that it could happen is they would be placed on suspense for a period of 2 general elections. And if they don't update their address in that time, then they would be removed from the voter roll. It makes common sense. It just helps the voter registrar put clarity on what actions they need to take. Send them a confirmation notice.
Members, any questions?
Thank you.
Thank you. The chair calls Alexei Swirsky. Alexei Swirsky. Okay, members, Keith Ingram with Secretary of State's office is here. Would you like to hear from him?
I would.
Okay.
Yeah.
Mr. Ingram, would you please come up? Good morning.
Morning, committee. Keith Ingram here from the Secretary of State's office on House Bill 1406.
Representative Israel.
Thank you, Madam Chair. Good morning, Mr. Ingram. I'm having trouble understanding the need for this bill. If the scenario is that I challenge somebody's voter registration, don't we have laws in place to take care of that scenario?
The 4 sections that are referenced in this bill all do that, yes, ma'am.
Mm-hmm. I don't understand the need for the additional language in the bill. Has there been a problem that we're trying to fix here?
Not that I'm aware of, no, ma'am.
Could you walk us through what is intended to happen with the law right now as it exists if I challenge someone's not living there or improperly registered?
If there's a challenge based on residence.
Can anyone challenge to? I'm sorry to interrupt you, but could you just walk us through what the law states now?
Sure. The law says that if a person has personal knowledge that a voter doesn't live at a particular address, then they can challenge based on residence. The voter registrar has to send a confirmation notice, which if the voter responds back and says, yes, I do live there, then that's the end of the hunt.
Mm-hmm. So it could be anybody who says, I think this person is voting improperly. I don't think they are living where they say they live or registered where they should be registered.
That's right.
They would send that notice to the who?
The voter registrar gets the sworn statement from a person who wants to challenge the residence of a voter, and the voter registrar sends a confirmation notice to the voter.
Okay. So is that all spelled out, the process in?
It is.
Is it?
160921.
So each county complies with that right now?
Yes.
Okay. And then what does each county do to follow up on that?
Well, if the voter doesn't respond to the confirmation notice, then they go into suspense, and they're in suspense for 2 federal elections. If they don't update their address in that time, then they're canceled at the end of the second general election they don't vote in.
Okay, so it's uniform around the state, what the procedure should be in each county in Texas?
That's right.
Okay. Thank you.
Thank you.
Members, any other questions? Representative Swanson.
Thank you, Madam Chairman. Can you tell me what would be the proper procedure if 4,000 people were registered at a whatever UPS mailbox? You know, it's very doubtful they all live inside a little space this big.
I would doubt that, yes.
So what happens if they answer back and they say, oh, yes, I do live in this little box this big. All 4,000 of us do. What's the procedure? What could be done at that point?
Well, as far as their voter registration, they stay registered and they stay an active voter. The voter registrar, if they believe that that is not the case, can refer them to the district attorney for lying on their voter registration application.
Okay. My other question is, if you're saying that the law is already okay, why did we have such an extreme problem in Harris County?
The issue in Harris County was the county attorney did not feel like Mr. Vera had sufficient personal knowledge of the voters' residence addresses. That the statement that was sworn statement didn't tie in the personal knowledge well enough, is my understanding of what the
Merely saying I don't believe all those people can fit in a little teeny box is not good enough?
It was the personal knowledge aspect that was challenged by the county attorney. And so the county attorney, it's my understanding, told the voter registrar not to take any action on those.
But then it was overruled, is that correct?
I don't know what's happened with it.
Okay, all right, thank you.
I think it was just the wording of the statement needed to be a little tighter.
Okay, thank you.
Members, any other questions? Mr. Ingram, how would this legislation change that?
It wouldn't. This legislation doesn't change anything right now.
Okay. Thank you. Any other questions, members?
Yeah. What?
Representative Kane?
Mr. Ingram, so if it's not changing any laws, is it adding any clarity to laws?
I don't know. Maybe. I don't think it changes anything.
Okay. Does it help clarify things then? By tying all those, by cross-referencing those code sections, it doesn't help clarify
But they're
that
already
related?
cross-referenced in each individual section, refers back to 15051. This just puts it in that. I don't know that it does anything.
Okay. Thank you, Mr. Ingram.
Thank you.
Other questions, members? Thank you very much. Is there anyone else wishing to testify on, for, or against House Bill 1406? The chair recognizes Representative Dean to close.
Thank you, Madam Chair. Basically, where does legislation come from? Since joining the House, I've worked on various election laws. Currently, in my Gregg County, we have an ongoing investigation of voter fraud via mail-in ballots. So I've had an interest in this from day one. And basically, we're talking about consistency. You have 4 parts of the code pointing an arrow to 15.051, but there aren't any arrows pointing back in 15.051's pointing in the 4 parts of the code. So imagine as a registrar, you start in 15.051, all you have got to go on is reason to believe. I think that's a vague standard. Why not clarify it as it's clarified in the 4 actual sections? With that, I'm happy to take questions.
Members, any questions? Okay. Thank you very
Committee, I
much for
appreciate it. Thank you.
presenting this bill. If there are no objections, House Bill 1406 will be left pending. The chair hears no objections. House Bill 1406 is left pending without objection. The chair lays out House Bill 2106 and recognizes Representative Pacheco to explain the bill.
Madam Chair, thank you for hearing this bill together, and the committee, thank you for being here this morning. House Bill 2106 is a very simple bill, just got one little change. And what that is that this bill seeks to expand the feet outside a door which a voter may enter the building from 100 to 300 feet. And why I think this is important is because, and I'm not sure about all the counties around Texas, but I do know a lot of knowledge about Bexar County, and I've heard other instances in the southern counties as well. And in some instances, we have fights, arguments, altercations have broken out between electioneering personnel, and this is all going on with sometimes with the voters and sometimes among opposing people from the different camps. And this also causes police officers that have other duties and other county officers to have to come, constables to have to come up and, either break up the fights or and that type of stuff. So at many times, local law enforcement must be hired to ensure peaceful voting, which increases costs. Additionally, in the recent polarization of the national election climate, extending the distance limit from 100 to 300 feet will provide a proactive, safe distance for voters and election workers. All too often we have voters coming to the polls to vote, and they have to run a gauntlet of people that have to, that everybody's tugging at them. So currently in the United States, 5 states have limits on electioneering exceeding 100 feet, ranging in limits as high as 600 feet. Our neighbor to the north, Oklahoma, has 300 feet, and our neighbor to the east, Louisiana, has 600 feet, just to give you an example. And things there are running very smooth. So that's my layout, and I respectfully ask to reserve the right to close.
Any questions, members? Ready, thank you. The chair calls Alan Vera. Please state your name, who you represent, and your position on the measure.
Alan Vera, Chairman, Harris County Republican Party Ballot Security Committee, testifying on HB 2106. We applaud Representative Pacheco for this bold bill, and we agree there's just too much unwarranted distraction and activity near the entrance to polling places, both during early voting and Election Day. However, we have to point out 2 issues related to the bill that have to be considered. One, I've worked as an alternate judge in many elections, and mostly in older school buildings in mature neighborhoods. Enforcing even the current 100-foot limit would put the campaign signs and the campaigners in the middle of a street. The presiding judge and I have always reached agreement that the chain link fence around the edge of the school property will be the electioneering barrier. Sometimes it's 65 feet, sometimes it's 75 feet, but we both agreed that putting the campaigners out in a busy thoroughfare across 4 lanes of traffic from the poll was not practical. This bill to move the 300 feet line, move that line out to 300 feet, will meet some resistance and will be difficult to execute. Point 2 is enforcement. I've gone to the district attorney with affidavits, photographs taken from outside the 100-foot barrier, other forms of evidence that candidates and workers were violating the 100-foot barrier. I've always gotten the same response. Mr. Vera, we appreciate your good work, but this is just a misdemeanor, and we can't put this in line in front of felonies. I'm sorry. If you want to make this work, try to elevate the offense to a felony, and we'll consider it seriously. I believe the bill's author is sincere, and the issue is real, but I think we have a couple issues to overcome before we can move this forward. Thank you.
Mr. Vera, let me confirm again. You testify in the kiosk. You said you were testifying on the bill. Is that correct?
I'm on the bill. Uh-huh.
Okay, thank you. Members, any questions?
Thank you.
Thank you. The chair calls David Covey.
David Covey, Orange County Republican Chairman and Legislative Chair for the TRCCA, today testifying for myself against this bill. This would effectively, at least in Orange County, eliminate the ability of our campaigns to work the polls. 300 feet would put us across the highway in many instances. It's a very difficult thing for rural counties. Often our locations, polling locations, are very small. So I think this is very impractical and have concerns about it limiting the ability of campaigns to effectively work the polls. I do appreciate the sentiment and the effort and do understand why it was brought, but I think it's very impractical, especially in our county. So with that, would urge the committee to vote against the bill. Thank you.
Members, any questions? Representative Swanson.
Thank you, Madam Chairman. Do you feel that this bill would take away your First Amendment free speech rights?
I think it could. I believe that in our county, for example, we have locations where if we had to go 300 feet, the voters coming into the polls would never see any signs. So it would eliminate the ability to work those locations, yes.
Do you feel that it's important for voters to get a chance to meet the candidates and meet their elected officials? This very often is the only chance that they get to do that.
I think this is one of their last chances to make up their mind, and often their first chance to meet the candidates. And so I think it's a very important right to be able to do that, and important for us as a state to protect that right.
Okay, thank you.
Other questions, members? Thank you for being here. The chair calls Chris Davis.
Thank you, Madam Chair. Good morning, members. Chris Davis on behalf of the Texas Association of Elections Administrators, testifying against House Bill 2106. This is essentially a football field length increase, an increase of 3 times of what the current area of responsibility is for the doors or entranceways to a polling place, and along with some of the issues that have been mentioned in testimony preceding mine. In this pushing of the area of responsibility, this area of responsibility would, of course, be pushed to busy streets, bustling parking lots, and also into private property, to backyards where, under this bill and increasing this radius, would it prohibit a private property owner from posting campaign signs? We believe it would. The fights that the author mentions that happen, or the arguments that happen between campaigns, will still continue, just further out. The police will still be called if these fights or disagreements escalate, just further out. But in this instance, our poll workers will be required to leave their post and venture a football field's length at most to deal with the situation. We think it's an undue burden. Thank you.
Questions, members? Thank you for your
Thank you, ma'am.
testimony. Chair calls Brandon Moore.
Madam Chair, members and guests, thank you for your time this morning. My name is Brandon Moore, and I am speaking against HB 2106 on behalf of myself. Had a script prepared out, but a lot of what's already been said covered that, talking about the fact that it is a football field. This could potentially stifle political free speech and severely limit the ability of candidates, campaigns, and even just activists who want to get out and support their candidate from interacting with the public. What I might add is that in my 2+ decades of experience in the political realm, serving as election judge, emergency judge, etc., I've seen where these things shouldn't really be an issue, and oftentimes, candidates need to consider who they have out there helping them, because those people are a reflection on them. The candidates want good people out there, and if they have problems with their electioneers, they're going to get rid of them. I think we can all see that we can function in a civil society, and for those reasons, I must speak against this bill this morning.
Members, any questions? Thank you.
Thank you.
The chair calls James Dickey.
Good morning, Madam Chair and members. My name is James Dickey. I'm chairman of the Republican Party of Texas, testifying in opposition to the bill on behalf of the party. One of our basic tenets is freedom of speech, and as former county chair for Travis County and our 150-plus voting center locations, I know firsthand that this would effectively eliminate any chance for any candidates or any of their supporters to speak to any voters at one of the most pivotal moments in the process. And that's not that is not positive either for the candidates or for the voters who lose out on a chance to be better informed. And so for that reason, we must oppose.
Members, any questions? Thank you.
Thank you.
The chair calls Fatima Menendez.
Chairwoman Cook, Vice Chair Cortez, and members of the committee. My name is Fatima Menendez, and I'm a legislative attorney for MALDEF, the Mexican American Legal Defense and Educational Fund, testifying against House Bill 2106. For decades, MALDEF has conducted litigation and policy work on voters' rights issues across the nation and here in Texas as a nonpartisan civil rights organization on behalf of Latinos. I think my testimony may answer a couple of questions that Representative Swanson had earlier. MALDEF opposes House Bill 2106 because the expansion of the 100-foot zone to 300 feet could infringe on the constitutionally protected rights of candidates and other campaigners to engage in electioneering activities. The First Amendment allows interaction between candidates and other campaigners and voters outside polling locations. In many cases, expanding the zone to 300 feet could push candidates and other campaigners off the property where polling places are located. Although some actions may be subjectively considered distractions, the First Amendment permits certain electioneering activities like standing outside a polling place holding up a sign, handing out campaign cards, asking voters to support a candidate, peaceful leafletting, and wearing campaign T-shirts. Precision must be used by governments when the government seeks to protect its legitimate interest and First Amendment freedoms are involved. HB 2106 could violate the constitutionally protected right of candidates and other campaign workers to be able to interact with voters as they enter a polling location. We echo the sentiment that was expressed earlier that this is impractical legislation, and we urge this committee to reject this bill. Thank you for your time.
Members, any questions? Thank you.
Thank you.
The chair calls Ed Johnson.
Ed Johnson, testifying for myself. I'm against House Bill 2106. As being a former director of county clerk's office, picking the 700 polling locations in Harris County, I will tell you the majority of them, this would put the workers, the people trying to interact with the voters in danger because they will be across the road or some other place. The only one that I haven't heard in the testimony so far is I think it would also be very confusing to voters. Voters actually use the campaign signs to usually find where the polling location is. So if you're having 300 feet away, it's going to be on the building next door, and they'll be all going in the building next door to go vote instead of where it's actually at. So I think it's better to keep it more centralized right around wherever the polling location is.
Members, any questions? Thank you. Members, we have Keith Ingram here. Does anybody have any questions for Mr. Ingram with the Secretary of State's office? Okay. All righty. Is there anyone else wishing to testify on, for, or against House Bill 2106?
I did register.
You have to register at the. Did you wish to register? And
Thank you for letting me do that. My name is Kelly Cook. I'm from Montgomery County, and I oppose this bill.
And you're representing
I'm just
yourself?
representing myself.
Okay, thank you.
I could be representing all the people that electioneer during campaigns like myself, though. That's usually where I spend my time during elections. And for statewide races, I don't think this bill would have such an impact, but local races like school board, city council, races like state reps, sometimes this is the last chance voters have to talk to representatives, and I've seen a lot of decisions be made at that last minute on down ballot races. Some people could consider me the gauntlet because this is where I like to work, and on issue campaigns, bond campaigns, this is the activists where you get a chance. You don't have a lot of money. You don't have money for flyers and mailers and all this stuff. So sometimes that's your last line of defense is working at the polling location. So anyway, thanks for letting me speak. That's all I have to say.
Members, any questions? Is there anyone else wishing to testify on for or against House Bill 2106? The chair recognizes Representative Pacheco to close.
Madam Chair, committee, thank you. Just in closing, I just wanted to say that the intent of this bill is to respect the voters. The voters are the number one priority that I had in mind for this. And if there's no other questions, with that I close.
Representative Cortez.
Thank you, Madam Chair. And Representative Pacheco, I appreciate you bringing this bill forward. I know what you're talking about, and you and I represent the same portions of Bexar County. And so I see what you're talking about every time, any voter goes to some of our polling locations. As soon as they're getting out of their vehicle, they're immediately harassed by poll workers or campaigners getting a little too aggressive. I've seen where there's been altercations at the polling sites, and so, between campaign workers specifically more so. And so I know what you're trying to do, and I appreciate you bringing this forward. And maybe we can continue to discuss this and look at a future committee substitute, because I do believe this discussion needs to continue as to how we can better protect the voter and not subject them to the constant harassment that they're getting, whether it's aggressive or maybe not so aggressive. Either way, something has to be addressed. And so I understand what you're trying to do, and I appreciate you bringing this bill to us to continue the dialogue.
Thank you.
That's all I have, Madam Chair. Thank you.
Any other questions? Thank you for presenting your bill. If there are no objections, House Bill 2106 will be left pending. The chair hears no objections. House Bill 2106 is left pending. The chair lays out House Bill 542 and recognizes Representative Cortez on behalf of Representative Navarez to explain the bill.
Thank you, Madam Chair. And this is a bill I'm laying out for my colleague, Representative Navarez. And House Bill 542 would make a photo ID issued by a federally recognized tribe an acceptable form of identification at the ballot box. The purpose of this bill is to make the ballot box more accessible to Texas voters, specifically our 3 federally recognized tribes in Texas. 11 other states do currently allow tribal ID as an acceptable form of identification at the ballot box. With that, I'll be happy to answer any questions on behalf of my colleague, and I do reserve my right to close, Madam Chair.
Members, any questions? Okay. The chair calls Alan Vera.
Alan Vera, Chairman, Harris County Republican Party Ballot Security Committee, testifying in opposition to HB 542. We recognize the unique political and legal positions of Native American tribes in Texas, so we understand and appreciate the general logic behind this bill. We are opposed to the bill because we have no information on the process and security measures that are supporting the issuance of tribal ID cards. Additionally, we're not aware that any state agency audits or oversees the ID card issuance process to verify its accuracy and integrity. And perhaps most important to the election process, we know of no agency that regularly or periodically audits for duplication of tribal photo ID cards. If we had assurance of state-level oversight of the issuance process, we might be able to change our position. However, with the information we currently have, we have to oppose this bill and ask that you not pass it out of committee.
Members, any questions? Thank you. The chair calls Rick Celestine. Please state your name, who you represent, and your position on the measure.
My name is Rick Silverstein. I am Vice Chair of the Tribal Council for the Alabama Coshada Tribe of Texas. I am here to testify in support of House Bill 542. The Alabama Coshada Tribe of Texas, which is one of 3 federally recognized tribes in Texas. Our reservation is located in Pope County, southeast Texas, about 90 miles north of Houston. Our identification card with a photograph should be included as an acceptable form of identification for voting. Our tribal IDs are issued through Tribal Enrollment Office with verification of birth certificates and DNA testing. They have a rigorous process for certifying tribal citizenship and produce an identification card that are almost impossible to forge. The current acceptable forms of identification at the polls, such as Texas driver's license, DPS-issued state IDs, and passports, all require street addresses, which may be problematic for tribal citizens living in remote reservations. Some tribal citizens may rely on post office boxes for mail delivery due to non-standard forms of street addresses on some reservations. Many of our elders do not drive and so do not have a Texas driver's license. Including the tribal citizenship identification card on the list of acceptable documents at the polls will remove those barriers and encourage participation in the election process that other Americans now enjoy. Tribal leaders work hard to continuously remind tribal citizens how important it is to vote in the state, local, and federal elections, with decisions being made at the federal level that could directly impact us. As a federally recognized Indian tribe, the United States maintains federal trust responsibilities and federal legislations which may directly impact our tribal programs. The President appoints the Secretary of the Department of Interior and Assistant Secretary of Bureau of Indian Affairs, who are in charge with implementing federal trust responsibilities. They will make decisions that affect our daily lives on the reservation. Supreme Court appointees and the U.S. senators who confirm them are important to us. While our reservation is in a remote rural part of the state, federal issues like health care funding have an immediate impact on our tribe. For the tribe, the verification of tribal identification card would be a seamless process for poll workers. The Alabama Coshada Tribe and the Polk County Clerk's Election Division have a long-standing working relationship. The Tribal Administration Building on our reservation serves as a polling location for our precinct. Tribal citizens who routinely volunteer to work election polls for Polk County would easily be able to determine if a tribal identification card is legitimate. They would also be able to train non-tribal poll workers on acceptable tribal identification cards. In closing, I would like to point out that the Alabama Coshada Reservation, which was established in the 1780s, is the oldest reservation in the state of Texas. Our ancestors supported the Texas War of Independence from Mexico and later in its quest to be annexed by the United States. Governor Sam Houston recognized our tribe's loyalty and secured the funds for the state to purchase land for our tribe to have a permanent home in East Texas. I share this piece of history to make the point that our tribe has resided in the state, so it is ironic that we have to produce a street address as evidence of residency to participate in the democratic process in Texas. Thank you for your time. I'm happy to answer any questions that you may have.
Representative Busey.
Thank you, Madam Chair. Rick, thank you for being here. Just a clarification, because it was asked earlier about not knowing the the process to get the ID. You talked about y'all go through a DNA test to get your ID?
Yes, sir.
Okay, so it sounds like y'all are going through stricter standards than what we go through.
Yes, we do. We copy the state Texas driver's license. We have the blue background. We have the signature authentication. We use the signature pad like the state does. We have a front and back picture. The watermarks are laminated on there. I mean, the watermarks are on there, front and back.
And it's a swipe card too?
It is. We're
Okay.
working on that as well.
Okay. Well, I appreciate it. It sounds like it's sounds like a stricter policy than what we go through. It seems like it would be secure to me. I
Yes, sir.
appreciate your
And
time.
we're always trying to enhance the program itself, just.
Thank you, sir. Thank you, Madam Chair.
Members, any other questions? Do you, your cards here, and they're passing it down, it does have things like dates of birth included
Yes,
on it?
ma'am, it
and
does, and it does have an expiration date on it as well.
And how long are they usually valid?
For 5 years.
For 5 years. And so then they have to go in and
To renew and take a picture again. Yes, ma'am.
Okay. And okay, on yours, I'm looking at, you do have an address, but you say some of your members would not have an address.
They would, but it would, I don't want to say it wouldn't be correct, but, it's in a rural area. It's just kind of hard to say exactly how it would be written on that thing. It would be some kind of address.
So it would be maybe a description?
Even a P.O. box, maybe. Ma'am?
Would it be maybe a description?
It probably would be.
Okay.
We, for the most part, most of our citizens on our reservation have an address at this point, but there are some reservations that do not. They live in rural areas and they do not have physical addresses.
So you said that those are DNA verified.
Yes, ma'am.
I would imagine that it takes quite some time once somebody applies for a tribal ID. Would that be
Yes, ma'am.
correct?
We try to take care of that at birth. From this, from a couple of years back, from that point on, we try to take care of it at birth. But yes, if somebody an elder was applying for one, yes, they would go through that process as well.
Okay. Alrighty. Thank you very much. It was fascinating. I'm sorry, Representative Kane.
I mean, I will say, just from looking at it, and being of a college age when people were making fake IDs a lot more, this thing, really, for those in the audience, if you weren't to see it, it looks much more secure than our driver's license, actually. So that does bring some ease. I mean, it looks like a lot more complicated to make that than it does the
Yes,
the
sir.
Texas
We're
driver's
hoping
license.
It is, sir.
Thank you.
Okay.
The chair calls Ed Johnson.
Ed Johnson here representing myself. I am against House Bill 542. This is not the first time we've heard this bill. This is about the third or fourth session we've heard it. One of the problems is, Alan Vera mentioned, there are multiple tribes in Texas, and they do not have any standard between tribe to tribe of how that ID is created. Some tribes do a very good job like that one you saw, some do not. So there isn't any uniform standard to all the tribal IDs here. In our election code last session, we actually made provisions for the people that are seniors, that can't drive, that can't get out. They have a reasonable impediment form that they can fill to vote. So there isn't anybody being denied the right to vote at the polling locations. Everybody there has the ability to go vote in it. And as far as the address, there are multiple rural people living in rural counties that don't have physical addresses, and you just give a description on your voter registration card, and that's how you register to vote. So I would oppose this bill because of the lack of standards in it. You'll find that most of these people do have driver's licenses because that is what is used in the public for doing practice of business.
Members, any questions? Thank you.
Thank you.
Members, we do have Keith Ingram here if you care to hear from him with Secretary of State.
Yes, I'd like to ask a question, Secretary of State.
Keith Ingram, Secretary of State Elections Division, here on House Bill 542.
Representative Israel.
Thank you, Madam Chair. Thank you, Keith. It's frustrating to me that this isn't a simpler process. The bill, as it's written, simply says at the end of all the other approved ID that this would be acceptable. Is it? What would be the process for the county to? I guess my question is, I'm hope that we're not fixated on the fact that this person is or isn't a member of the tribe, as opposed to the purpose of the card is just to establish identity, correct?
That's right.
So the state of Texas isn't going to get into the business of who is or isn't 132nd or 118th Native American. It's about, is this person on this image who is presenting themselves to vote, right?
Right. It's for identity purposes to make sure that the person is who they say they are.
And in terms of the level of detail, if we were to add this to the statute and say if you're a member of the tribe and there's a number of them who may not have a driver's license and who want to, but who are very proud and have a cherished document to establish their membership in the tribe, what would be the process to adopt that at the county level if we were to pass this bill? Is there any structure beyond just simply saying, here's one more ID that can be used?
Well, we would update our training to include pictures of the tribal IDs that we have here in Texas to, as many of them as we could get a picture of so that the poll workers could be trained as to what they look like.
So it's a familiarity issue, not it's not an issue of is this a valid document or not.
That's right.
Okay.
And now you could vote with a reasonable impediment declaration and another government document that's got a picture and an address on it. So this would be a secondary form of ID that would support a RID right now.
Mm-hmm. How many other states accept this as a form of ID?
I do not know.
Okay.
I could do some research, but I don't know off the top of my head.
No, I don't want to create more work for you. I just thought you might have that on top of your head. Perhaps our author can get us an email with some backup info, too. Okay. Thank you, Keith. That's all I had.
Thank you.
Any other questions, members? Thank you. The chair, anyone else wishing to testify on, for, or against House Bill 542? The chair recognizes Representative Cortez to close on behalf of Representative Navarez.
Thank you, Madam Chair. And this bill, once again, is to encourage participation in our democratic process. And I appreciate Representative Ida's introducing this bill. If there's no other questions, Madam Chair, I do close.
If there's no objection, House Bill 542 will be left pending. The chair hears no objection. House Bill 542 is left pending without objection. The chair lays out House Bill 552 and offers a complete committee substitute, and the chair recognizes Representative Canales to explain the measure. Welcome.
Thank you, Chairwoman. It's my first bill before you, Vice Chair. 522 simply removes an administrative step for high schools in order to better facilitate the circulation of voter registration forms. It seeks to provide, without request, voter registration forms to high schools and make these forms available year-round. Currently, the election code states that a principal or designee of a public or private high school shall serve as deputy registrar And as Deputy Registrar, one must request voter registration forms from the Secretary of State at least twice a year and distribute those forms to eligible students, employees of the school, and collect and return those forms to be processed. Unfortunately, while the Secretary of State does notify the school, the duty is not often being fulfilled by the actual schools. And so, excuse me, allergies are getting me this time of year. Research by the Texas Civil Rights Project and the League of Women Voters has shown that many high schools are not complying with the statute or the law, excuse me. I think it's important that we encourage young people to be active members of society, and I don't think that the current statute around high school registration helps our school administrators. By having the Secretary of State automatically provide the voter registration forms to high schools and having these forms available year-round, we reduce paperwork, we help high schools more easily abide by the law, and we increase student access to the registration forms. The committee substitute removes Section I from the bill, which prescribes the kind of forms to be sent by the high schools. This bill is a suggestion from the League of Women Voters, and if there's no question, I reserve the right to close.
Members, any questions?
Thank you.
The chair calls David Covey.
Thank you, Madam Chair and members. David Covey, Orange County Republican Party Chair, speaking on behalf of myself. I think this is a good intention bill, and we certainly want everyone to vote that can vote. The problem is it seems to open up the door. My position would be I am against this bill. Thank you. The problem seems to be that it opens up the door where we could then start requiring these applications to be at just about any location. And so right now it seems like it's already duplicative. We can already have applications there. So this seems to be burdensome to the schools. For that reason, I would be opposed to this bill. Thank you.
Members, any questions? Thank you. Chair calls Alan Vera.
Alan Vera, Chairman, Harris County Republican Party Ballot Security Committee, testifying on HB 552. We find nothing inherently wrong with the bill except that it adds more work for the Secretary of State, the Texas Education Agency, and the County Voter Registrar. And it might also lead to a bad experience for the high school students who are eligible to register to vote for the first time. We prefer the current process be enforced and followed through, where deputy voter registrars are available at the high school to help the students sign up, to answer their questions, and to provide them with a quality control process to avoid having their registration application questioned or rejected by the registrar. We think this would be a better first-time experience for first-time voters. HISD, Houston Independent School District, and other ISDs in the county already have a DVR program in place under current statute to help ensure the students' first experience with voter registration is a positive one. So we're concerned if the schools simply have the applications available for students to take, if there's no one available to answer questions about the correct way to fill it out, if the school authorities haven't received their DVR training and they're being asked questions by the students, we think the chances of a bad experience grows. The current process using teacher DVR seems to be avoiding or at least reducing that problem. We don't think the bill's necessary.
Members, any questions? Thank you. Chair calls Brandon Moore.
Madam Chair, members and guests, thank you again for your time this morning. My name is Brandon Moore. Speaking against HB 552 on behalf of myself, while we all want to encourage our youth to learn about the political process, educate themselves about the candidates and issues, and become involved in elections, I'm not sure that this bill is quite the right approach. As was already been mentioned, there are resources available to them, et cetera, through volunteer deputy registrars already there. They can help assist them through the process, and I think making sure that we have those methods in place and that those methods are being followed according to the law is something we should do to help them through this process. Also, as has already been mentioned, the bill would increase the burden on SOS, the county registrars, and the Texas Education Agency. It seems to be complicating the process a little bit more. For those reasons, while I think the end goal of this bill is quite noble, and I certainly support the end goal of getting these students registered, as far as the actual approach on this one, I think I would have to disagree with this bill.
Members, any questions? Thank you. Chair calls James Dickey.
Good morning, Madam Chair, members, guests. My name's James Dickey. I'm chairman of the Republican Party of Texas, and I'm here on behalf of the party testifying in opposition to HB 552. Increasing voter registration, voter turnout is an admirable goal, and we've seen significant increases towards those goals over the past several years. The House has just committed significant additional funds to our public schools to ensure a world-class education for current and future generations of Texas students. Those students will have numerous opportunities to register to vote both inside and outside of school without the passage of this bill. In school, any qualified person could become a deputy voter registrar and organize a volunteer registration effort in addition to the options that are already available. But it would send a conflicting message at best for the legislature, after just making such a big commitment to education, to then divert some of the school's attention to complying with new requirements on things like the stock of voter registration cards and deputy voter registrar counts. So even though the goal is worthwhile, it's not part of the core educational mission, it's not necessary, and it's not part of it is in conflict to the message the House has just sent very vividly on the importance of education to Texas. We urge you to vote against this bill.
Members, any questions? Thank you. The chair calls James Slattery. James Slattery.
Chair Click, Vice Chair Cortez, members of the House Elections Committee, thank you for the opportunity to testify in strong support of HB 552. I'd especially like to express my appreciation to Representative Canales' office for inviting me to share my organization's expertise with you.
Could you state your name and who you represent?
Sure. My name is James Slattery, and I'm a senior staff attorney with the Texas Civil Rights Project, where I lead our efforts to promote compliance with the high school voter registration law. Current law requires each Texas high school to offer eligible students the opportunity to register to vote at least twice each school year. This important law embodies an important Texas value that voting is the lifeblood of our democracy, and our democracy becomes stronger when more people participate in our elections. Numerous studies have shown that when young people learn the voting process early on, they are more likely to continue their democratic participation later in life. It also increases the likelihood that others in their households will vote, especially among communities of color and immigrant families. The high school voter registration law works to bring our youngest voters into the democratic process by ensuring they are offered the opportunity to register to vote as soon as they are eligible. This bill would enact important and helpful updates to the law to make it more effective. Under current law, high schools must reach out to the Secretary of State for voter registration forms in order to receive them. But my organization's research has discovered that the law would work better if the primary responsibility for ensuring that schools have sufficient forms lies with the Secretary of State. In a report that we published last year, we found that only 34% of schools lodged a request for forms from October 2016 to February 2018. Further, we learned that many schools experienced delays in receiving forms from the Secretary or did not even receive the forms that they had requested. HB 552 would potentially substantially alleviate that problem by requiring the Secretary to work with TEA to determine how many forms each school needs to register students, and then affirmatively provide that number of forms to schools. This common sense reform would ease burdens on schools in obtaining forms and make it more likely that those forms will end up in the hands of students eager to participate in our democracy. As a result, we urge the committee to adopt HB 552, although we would suggest adding a requirement that the Secretary provide the required number of forms at least once each school year. Thank you for your time.
Members, any questions? Had you investigated whether or not the local county officials may be providing those rather than the Secretary of State?
Yes, and in fact, we believe and we have evidence that they are. So forms are getting to schools in other ways. But of course, one of the ideas behind the law is that it should be as easy as possible for schools whose primary responsibility is not election-related matters to have the forms as easily as possible. The Secretary of State being essentially the chief officer in the state for administering our elections, since they have the forms on hand and they have access to this statewide data or could be given access to this data, that could really make it easier for our schools whose primary mission is to teach kids.
So you said you had researched whether or not they were in fact obtaining those forms at the local level. I mean, can you share any of what you learned?
So we don't have precise data on that. Unfortunately, at this time, the Secretary of State does not have a tracking mechanism to make sure that every school in the state is getting forms and to follow up with those that aren't.
But that would be the Secretary of State's office. But those forms are also available at the county level as well. And have you investigated, whether in fact some of those schools may be getting those forms from the locals?
And they are, but what we've been able to determine is that it's very patchwork. It very much depends on which county you live in, how responsive the county election official is. It really depends on where you live in the state.
I mean, because that may be a means of getting those to them quicker. I mean, it's not something that necessarily has to come through the mail. It's something that somebody can pick up, providing that information is kind of a dual role of both state and county government. Would you agree?
Yeah, and the system will work best if every part of the election infrastructure works together.
Sure.
And so county election officials definitely working with their local schools. But that also sort of highlights the Secretary's key role here as a potential high-level driver of that process to make sure it's getting done.
Thank you very much. Any other questions, members? Thank you.
Thank you.
The chair calls Ed Johnson.
Ed Johnson, testifying for myself. I am against House Bill 552. As working in the election world for 18 years, being in charge of voter registration, I can tell you all of these schools are doing this. The Secretary of State is doing a great job. They have the tool that kids use. Kids, younger generation, do not use paper and pencil anymore. They use their phone and iPad. The Secretary of State has a wonderful website that explains exactly how you register to vote. It's, votetexas.gov, powered by the Secretary of State's office. This is what my seeing in the office, this is how all the young people register. They don't use the paper card to mail in anymore. They get out their computer and iPad. Every school has computers. They all have printers. It's all available. That's what the teachers are actually using. This is a step-by-step tutorial for the teacher that steps them through exactly how the person's registered to vote. You click the button here, and it takes you to a form that takes you and explains every step of what the card does the whole way down. This is what the teachers are using. This is what kids use when they fill out to register to vote. I think this bill is a waste of government money to have to provide all this cards and paper that would just never be used.
Members, any questions? Thank you. Members, we have Keith Ingram with the Texas Secretary of State's office here. Does anyone have any questions that they have for him? Okay. All righty. Is there anyone else wishing to testify on, for, or against House Bill 552? The chair recognizes Representative Canales to close.
I didn't realize, thank you, Chairwoman, I didn't realize this morning I was going to have so much, I was going to be so entertained with Crazy Town. But so this is the law already. This is the law. Schools are supposed to be requesting these things. So to imply that this is going to increase the burden on the Secretary of State is disingenuous. To imply that this is going to create a cost is disingenuous. The fact is, this is the law. This is what they should be doing. Now, you had, we won't go into partisan politics here, but you had one of the party chairs come up and say that the reason that we shouldn't do this is that schools should focus on education. That's what the bill does. It allows schools to not have to deal with this because it's not the school's obligation. It's the Secretary of State's obligation under the law. Basically, what this does is exactly what that person came up here and told you we shouldn't be doing. We shouldn't be making schools do this. That's what this bill does. It allows schools to focus on education and not registering kids to vote. Then you had somebody come up here and say, got an iPad. That's brilliant because you can't register online, and everybody on this committee knows that. You register with a paper and a pen. That's the reality in Texas. So the reality is Texas schools are not following the law. The reality is we're not doing what we're supposed to do, and we're putting this burden on high schools which are not complying. And so the fact is this bill is real simple. Send them the forms. Send them the forms. So schools they can focus on education, and it's not an extra burden because it's what they should be doing in the first place. So if there's not any questions, or if you have any questions, I'd be happy to answer them. But the testimony before this committee was that from almost every single person was not only disingenuous, it was incorrect, and it's also, I encourage people to read bills before they come up here. So if there's no questions for me, I close, but I stand for questions.
Members, questions?
No, I mean.
Representative Kane, did you have a question?
How you doing, Representative? I feel a little bit passionate about when people don't read a bill.
About Crazy Town.
When I stepped into the twilight zone, I went down the rabbit hole, whatever you want to call it. Thank you. I close.
Any other questions, members? If there's no objection, the substitute will be withdrawn. The chair hears no objection. The substitute is withdrawn without objection. If there is no objection, House Bill 552 will be left pending. The chair hears no objection. House Bill 552 is left pending without objection. The chair lays out House Bill 2640 and offers a complete committee substitute, and the chair recognizes Representative Cortez to explain the measure.
Madam Chair, if it's okay, I would like to lay out from here.
Perfect.
Thank you. Chair Click, members of the committee, thank you for the opportunity to lay out House Bill 2640. Following every election cycle, problems are flagged and ideas generated, which would provide a more efficient and transparent election process in Texas. House Bill 2640 is the bill that seeks to update and clarify those laws in the Texas Election Code, which govern political parties. House Bill 2640 is a work in progress. Representatives from the Republican and Democratic parties have been meeting and will continue to meet following this hearing. I welcome this opportunity to hear from other stakeholders and interested citizens so that their comments and recommendations may be considered in the drafting of this legislation. With that, I'll be happy to answer any questions any committee members have, and I do reserve the right to close, Madam Chair.
Members, any questions? Representative Cortez, could you kind of detail some of the changes that were made in your committee substitute? The chair calls James Dickey.
Good morning, Madam Chair, members, guests. I'm Chairman of the Republican Party of Texas. My name is James Dickey, and I'm testifying here on behalf of the party, testifying on HB 2640. We are still working very much with Representative Cortez and his team to resolve the remaining differences. Much of this 2640 properly deals with, several months ago has happened in advance of many prior sessions. The staff of the Elections Division of the Secretary of State's office met with representatives from both the Democrat and Republican parties to discuss lessons learned from the most recent election and potential election codes needed, election code changes needed as a result. And that is the intent of the bill, is to address those mutually agreed on concerns. There have been many of those are issues that are, very straightforward, like whether or not the Secretary of State can deliver his certified list via posting on his website, right? I mean, that things like that are very straightforward and absolutely agreed to. There have been a couple of things that have been pointed out as being, potential end of the world scenarios, and the reality is they can be addressed in the committee substitute with as simple change as a couple of words. So one example that there's been all sorts of interesting conspiracy theories on is one of the changes that suggested that, or that added that precinct chairs or county chairs, whether elected or appointed per the party rules, a change related to that. There are numerous provisions in the election code that allow for the appointment of county chairs and precinct chairs. That if that is a great concern, though, those words "or appointed" could easily be removed from the committee substitute. So, for that reason, because we haven't seen the final, we can't speak definitively for, but I am very comfortable that we will finish process in the good faith effort that we have been working on up till now, and I'm sure that we will be able to provide a final version that we will be able to speak for.
Members, any questions? Thank you.
Thank you.
The chair calls Glenn Maxey.
Thank you, Madam Chair and members. And Glenn Maxey with the Texas Democratic Party. I'm passing out a letter that sort of lays out the process that we went through to get here today. Before the session, both parties met. We've had 6 in-person meetings. Glenn Maxey in support of House Bill 2640. We've had 6 in-person meetings, multiple emails, text messages, and late-night phone calls. I have put a section by section for the original bill of the Texas Democratic Party's position on each section. We have taken a position from the beginning. If anybody has any heartburn about anything that we put forward in this bill, that we will take it out. This is to be an agreed-to bill, as we've done every session as long as I've been doing this work between the two parties. So we think that is the method still to go. We are going to have a meeting yet again today to work through some final changes. At the end of my written testimony, I have a list of 5 or 6 other legislative ideas that can be rolled in, that I think both parties have agreed to, but haven't been in a document that anybody's seen. Some things that are just put some definitivity on how we file people for offices that could be rolled into this bill also. So we will continue to work, and our position at the Texas Democratic Party is that if anybody from either party objects, we are also been made aware that the county clerks and election administrators have a number of places in here where we've done some things that affect them, that they have some concerns about, and we're willing to take those sections out or rewrite those to meet their objections so that it is truly a totally agreed to bill at the end of this process. Thank you.
Members, any questions? Thank you. The chair calls Janet Jackson.
Good morning, Chairman and committee and guest. I'm Janet Jackson. I'm the Bosque County Republican Chairman, speaking for myself in opposition to some of the language in this bill, specifically Section 13, that would allow for a party rule which could eliminate the election of county and precinct chairs in the primary election and allow them to be elected or appointed by any method designated by that rule. I'm currently the training director for the Republican County Chairman's Association, having served as the immediate past president of this organization and 3 terms on the SREC. Through all of these positions, I've had a strong focus and history on county chairman and precinct chairman training. I've done this because I strongly believe that the ballot election of the county and precinct chairs is our connection to the true grassroots of each of our respective parties, and in as such gives our citizens a true voice in the direction of their respective parties. I feel this section of 2640 could drastically undermine the current structure of citizen activism and participation in the political process. Ballot election of these positions is our respective party connection to the voters, keeping a voice for the grassroots at the most basic level. I urge you to eliminate this language. Thank you.
Members, any questions? Thank you. The chair calls J.T. Edwards.
Good morning, Madam Chairman, members. Thank you all for serving the great state. I'm J.T. Edwards, representing the Republican Party of Texas as well as the Galveston County Republican Party in opposition. With due respect, with Representative Cortez, with your language, I believe that we have a couple other bills that are going to come up in this committee that will simplify what we're trying to get to as far as fixing the election code with the definition of electoral affairs and party affairs.
In your position on the bill?
Against. I apologize.
Thank you.
That's why you kept looking at me. I'm sorry. And I'll be happy for any questions.
Members, any questions?
Thank you, Madam Chairman. Thank you, guys.
The chair calls Alexis Swirsky.
My name is Alexis Swirsky. I am from Harris County. I'm against this bill. I'm a precinct chair for the Republican Party in Harris County. I actively attend our Harris County Republican Party Executive Committee meetings and the state committee meetings.
You're representing yourself?
I am representing myself. Thank you. Political parties are an integral factor in representative democracy. Political parties seek to win elections in order to manage government institutions through their choices of candidates and support or non-support of other issues on the ballot. They provide citizens with choices in government. Parties' organizational choices in regards to its internal procedures help to define what parties stand for. Parties generally adopt county rules to organize procedures and to define methods for making decisions. Some sections of this bill micromanage what I believe should be choices within a party. The Democratic Party should decide how the Democratic Party is run, and the Republican Party how the Republican Party should be run. The state of Texas should not dictate internal rules to each political party. And I realize not all of the bill deals with that, but I am concerned about micromanaging what should be done by the party. And that's why I mentioned that I attend meetings where these decisions are made and voted on. So the members of the Republican Party are given a choice in some of these rules, and I assume the members of the Democratic Party are the same. Although Will Rogers once stated, the more you observe politics, the more you've got to admit that each party is worse than the other. I do believe that each party should be free to make its own choices in fulfilling that statement.
Representative Kane.
Morning, Ms. Swirsky. Just a few questions, and please let me know if you don't know the section number specifically or where it's in the bill, but I'll give you a moment to collect your thoughts. What specifically are things that what do you like about the bill? How about that? Let's start with that. Are there things you could point to that you like?
I don't know. It's a 24-page bill.
Okay.
Honestly, I would rather be broken up into smaller bills. This is a lot, and it scares me when there's a bill that encompasses a lot that gets passed, that the author puts a lot in there to get passed, because that's how some bad wording gets into a bill.
Okay. How about, are there any specific sections you could point to that are just non-starters?
Okay, it says in the last section, section 54D, for a political party to be entitled to have its nominees for president and vice president of the United States placed on the ballot. It just says that it has to be posted on the party's internet website. So, like, is this the state party, or are we thinking the voters won't know who the nominees are for the presidential primaries? And I think when we get down to governing a state party's website, no, that's micromanaging. And I object to that. That's the last section in the bill.
Anything else, Ms. Swirsky?
I'm sure there's a lot more, but no, I'm not prepared to state all the details, so
Okay.
I'm sorry.
Thank you. And thank you for coming up today.
Any other questions, members? Any other questions? Thank you. The chair calls Chris Davis.
Thank you, Madam Chair. Members, Chris Davis on behalf of the Texas Association of Election Administrators. In opposition to House Bill 2640 is filed. Here's some of the parts that we like, in spite of us being against it. We like Section 4, where the parties are given 90-day advance notice of stamp, certificate, or affiliation certificate needs. We like Section 26, where it's permissiveness. Permissiveness is something that we always like, giving county election officers, be they EAs or county clerks, the ability to have discretion and negotiate some of these items in contracts with the parties or participating entities is always a positive. Some of the parts that we have an issue with, and we'd like to continue to be a party to this discussion that apparently has occurred between the parties, heretofore occurred mostly between the parties, given that we are the executing agent of a lot of these sections of the bill. In Section 2, we desire for the Secretary of State's office to continue the practice of posting certified candidates on their website and emailing individual counties their respective lists, because in November 2018, their online listing of certified candidates had significant errors in it for some counties. In Section 29, we believe it mandates county election offices, through the use of the language of authority conducting the election, to prepare multitudes of copies of party convention notices. We're generally not a copying house or duplication house. This should be something that should be negotiated in the contract on a county-by-county basis, whether they do it or not, and have that discretion. Section 31, we ask, are we now required to provide lists of voters same day on election day? That is something that may be a tall ask for offices that are conducting elections, that are preparing for the returns to come in, yet we then be provided or be required to provide a list of those same election day voters to parties, county parties that may be conducting their county conventions that same night. Happy to answer any questions.
Members, any questions? Thank you. Thank you very much.
Thank you, ma'am.
Chair calls Bill Patterson.
My name is Bill Patterson. I'm with I'm with Texas Press Association, and also owner publisher of Denton Media Company and the Denton Record Chronicle. I'm speaking against the bill as written.
You represent those
Texas
entities?
Press Association, Denton Record Chronicle, Denton Media Company. Speaking against the bill as written. The purpose of public notices is to make citizens aware of government actions and intent, and few things are more impactful in government than elections. The bill talks about newspapers, and that's where I really want to focus for a minute, because we also have our websites, and all of the public notices that are printed in our newspapers are also put up on our newspaper websites. They're also available on our e-replica editions, and so the amount of eyeballs that see that information is pretty significant. Our concern is if the notice is taken out of newspapers, that leaves out a lot of the people, and a lot of the people that read newspapers and websites are voters, and I think that's disingenuous for the voters to not be able to have that access. That's really what I have to say. Be glad to answer any questions.
Members, any questions?
Yes.
Representative Kane?
Sir, you said you're here with the Texas Press Association?
Correct.
Okay. And what is that?
It's a newspaper association, the statewide newspaper association in Texas.
And in order for these notices, do parties and entities, I guess, pay a fee to the newspaper?
They do pay a fee, and they pay the lowest published rate, which generally is not a whole lot of money, to be really honest.
Yeah. So it has nothing to do with money. You're not concerned about losing money?
A small amount of money, but it's not going to make or break us.
So
it's more about the public's right to know and the public's ability to be able to know what's going on.
Yeah. Do you live here in Austin?
No, I live in Denton.
So you drove here from Denton out of the goodwill of your heart to make sure people know something that has nothing to do with money?
Yeah, sure did.
Thank you.
You bet.
Other questions, members? Mr. Patterson, what types of notices in regards to this does your publication post?
Well, we publish all sorts of notices, I guess I should say. When you say what types of notices in regards to this, we publish like election polling location notices. We publish other notices related to election matters. We publish all sorts of notices.
Specifically, are there requirements that would be reduced in the bill as filed that would be reduced as far as the publication with?
Well, the way I read the bill is that newspapers would be removed from the notification that would just be put on the governmental websites.
Okay. Thank you. Any other questions, members? Thank you very much.
Thank you.
The chair calls Jack Barkoff.
Morning, Madam Chair, members. My name is Jack Barcroft. I'm the chairman of Coryell County Republican Party. I represent Senate District 24 on the State Republican Executive Committee, and I'm the president of the Texas Republican County Chairmen's Association, as well as 5 other jobs that pay about the same thing.
And you're representing today?
Myself.
Yourself, okay.
Yes,
in your
ma'am.
position?
Against 2640
okay.
in its current form. Boy, I tell you what, I thought War and Peace was a read, but this one's pretty healthy. And I greatly appreciate all the work that's going behind the scenes in order to turn this thing into something productive, right? But, you know, there's several sections I've got heartburn about, 8, 13, 14, just to name a few. But I just wanted to be on the record of speaking against 2640 in its current form.
Mr. Barkoff, in your online, your registration, it says that you are representing the County Chairs Association and yourself. Is that correct?
I should have done that for a different bill by itself.
Okay. Do you, and if that's so, then we might need to change what you've entered in. It's showing that you're testifying on behalf of the Texas Republican County Chair Association and
Absolutely
yourself.
Absolutely should have been on behalf of myself.
Okay. And we do have your permission to change that?
Yes, ma'am.
You'll have to go over and visit with Teresa when you get done here, and she can help you with that.
Thank you very much.
All righty. Members, any other questions? Thank you.
Okay.
The chair calls Brandon Moore.
Madam Chair, members and guests, again, thank you for your time this morning. My name is Brandon Moore. I'm speaking on HB 2640 on behalf of myself. This bill, as you've all heard, is a compilation of items from both parties that they would like to see changed in the election code. I've had the honor of being one of the people to run point on this bill and working with others from the Texas Democrat Party and Representative Cortez's office. I would like to thank Representative Cortez for filing this bill and for the work that everyone has put into this bill so far and the work yet to come. As I'm sure many of you have heard already today, there are concerns with the introduced version of the bill, but we've been working hard to address those concerns and working towards a committee substitute, which we hope we can all get behind and support. I look forward to continuing to contribute to this process and to what I hope will, that we all hope will be a good bill that we can all get behind and support.
Members, any questions? Thank you.
Thank you.
Chair calls Kathy Hagler.
Good morning, Madam Chairman and members. My name is Kathy Hagler. I'm currently the Republican County Chairman in Caldwell County. I've been there since 2013, but I've also served on the State Republican Executive Committee for 9.5 years, and for 2 years as the State Party Secretary, so I've got a little bit of perspective from all sides. I'm giving you a handout. I think Representative Kane will like it because I separated into what is good. I found 18 sections that I like, and then what is bad is pretty much everything else. There may be a couple of sections that are not in there because I just didn't want to have an opinion on them, but
You're testifying on behalf of?
I'm testifying against the bill, I'm sorry, against
on behalf
HB
of,
2640.
On whose behalf? Yourself?
For myself.
Okay, thank you.
Sorry, thank you. With as many things wrong with it as there are, I'm saying that I'm testifying against it, although I'm letting you know about a couple of things that are good, and I'd be happy to answer any questions.
Members, any questions? Representative Swanson?
Yes, Ms. Hagler, thank you for coming.
Thank you.
You look a little bit familiar. No, we've known each other many years. I appreciate this list here. Could you just kind of list out maybe just quickly your 3 or 4 favorite and 3 or 4 least favorite?
Definitely the one that you see in red, Section 28, is my favorite thing in the bill. It fixes some crazy thing that happened last session that said county clerks had to post information on the county party website, which that's just not going to happen. And so it clarifies it that county clerks post information on the county website and county chairs post on the party website, and never the twain shall meet. So to me, that's the best fix that we have in the bill. There's a lot of things in what is good that I'm saying it's just making better use of technology and not saying that you have to deliver paper. And so that's probably the bulk of the things that are good. Section 13 is the biggest problem I have, because it's saying, I'll read what I have there. Party rules should never be able to take away the direct elections of the voters in a county where they live, to instead make the county chairs appointed by state leadership or a state executive committee. The local voters and local election executive committee know what's best for their own county, not the people elected at a party convention from all across the state. That's probably my biggest concern there.
Members, any questions? Thank you for being here. The chair calls David Covey.
Thank you. David Covey, Chairman of the Orange County Republican Party, speaking on behalf of myself against the bill as is in its current form. This is a challenging bill to testify on just because of the 54 section. It is a lengthy bill. But we're hopeful that some changes can be made and this could move forward. Some of the sections that I'm against are Section 6, Section 13, Section 14, Section 15, Section 18, Section 20, and Section 49. A couple of the sections I think could be revised are Section 31 and 32, which require the county chairs to request from the county clerk to receive information. Instead, we would like to change that to where it was a default that the county chairs receive their lists, and maybe the county clerks could ask that it be waived. That was section 31 and 32. And then section 45 was just a little bit awkward. It allows for precinct chair or precinct conventions to go along at the same time that county conventions are going along. So it just seems like that creates an awkward scenario. So it has some work, I think. I think we have a commitment that the substitute is coming and be working on some of these issues. So against it in its current form, but hopeful that we can get behind a bill that we can work with.
Representative Kane.
Mr. Covey.
Yes, sir.
Thanks for coming from Orange, my friend. Could you explain to me your concern or opposition to Section 13?
Yes, sir. So in its current form, it replaces, or actually our recommendation for the substitute language had been or elect, or let's see, well, I'm on the wrong one there. So on section 13, I believe that is going to be actually taken out in the substitute.
Yeah, but could you explain why, the reason against it?
Yes, sir. It opens up the appointment of precinct and county chairs was our understanding on section 13 to the I guess the body and the rules. And we support county chairs being elected by the body, or by the election during the general election. I apologize for messing around here. So we believe that the county chair is closest to the people and should be elected. And so I personally oppose it going to be in an appointed position, and that's why I oppose 13.
Are there ever times where we need to, maybe the county, the precinct chairs, or whomever would like to get rid of a bad county chair? And do you think this addresses that?
I think there are situations where that certainly could become the case and has been the case. I think that there are mechanisms that do that already. I don't think that we need to open it this wide open.
Okay, thank you.
Members, any questions?
Yes.
Representative Swanson.
Yes. I would like to, two things. When you just ran through that you didn't like all those different sections, I have no idea what that all meant because I don't know what those sections are. I don't have the numbers memorized. Do you have your testimony in writing by any chance? And also, can you just verbally just tell us your 3 or 4 favorites and least favorite points? Like what they mean, not a section number.
Yes, ma'am. Yes, ma'am. So I do not have that in front of me, but I do have a spreadsheet that has been worked on with the author and with Mr. Brandon Moore and with Mr. Glenn Maxey, and we could provide that for you and for your office.
That would be great.
Yes, ma'am.
Any other questions, members? Thank you. The chair calls Eric Opiella.
Howdy. Eric Opiella, representing myself, testifying against the filed version of the bill. I know many of you have been involved, served on the State Republican Executive Committee with Representative Swanson, served as county chair in Karnes County for 4 years, ran the State Republican Party for 2 years as executive director, and also served as counsel for 7 years. There's, like previous witnesses have said, there's a lot of good things, there's a lot of bad things about this bill. I trust that people will work together to eliminate the bad things so we can get some of the good things passed, but not to repeat any of the testimony from prior witnesses. I want to focus on 2 issues that haven't been addressed by them. Section 53 and subdivisions 1 and 2 of Section 54. These are the repealer sections. Those are the ones you always have to watch out for because they're easy to miss. Eliminate the requirement that rules changes be filed with the Secretary of State and remove the prohibition on making rules changes during an election year. This is really important to not repeal. changing rules on election affairs once the electoral process has started allows for gaming of the system and interferes with free and fair elections. This change alone, last presidential cycle, would have allowed those who wish to undermine the choice of our primary voters to free the delegates and cause chaos at our national nominating convention. Sections 47, 50, and Subdivision 5 of Section 54 of the file version of House Bill 2640 would eliminate record-keeping requirements for conventions, specifically removing the requirements that list of delegates be signed, prepared, and delivered by the chairs of those conventions. That term is very important because it's referenced in other sections of the code which allow the voters to get public access to those records, because the only records relating to conventions that are public are those that are either delivered, signed, and prepared or required by the code. When we eliminate that requirement, we eliminate the open records access to those documents. That's real important because the integrity of the convention process relies on accurate, publicly accessible lists of the delegates selected at each process. Allowing changes to this process via party rules would undermine the ability of all voters to obtain and verify these public records under the election code. There's some other sections that obviously everybody's been working on. I'd be happy to answer any particular questions regarding any other section of the bill. Of course, Sections 13, and I want to mention Section 14 of the bill, which follows right after Section 13, is the caption that was changed through the elimination of election of county chairs. And so I want to make sure that that caption is restored back as well in Section 14 of the bill. Thank you. Happy to answer any questions.
Questions, members? Thank you.
Okay. Thank you.
Representative Swanson.
I need to have a buzzer on my light here. Thank you, Madam Chairman. Do you have a spreadsheet or something so that we could also have a record? Because it sounds like...
We'll email it to you.
Okay. Thank you so
Sounds
much.
good. Thank you.
Chair recognizes Ed Johnson.
Ed Johnson here representing myself, and I'm against House Bill 2640. Tried to hit some highlights that I hadn't seen. I was trying to look up codes. And I guess it's Section 162.04 where we're doing away with stamping the cards. I think you need to leave it optional to where if the party requests for it to be stamped, it could. With countywide voting going on, it could be difficult if the county is not able to produce an electronic list of who voted that day, promptly. You would always have the paper card back up.
Real quick, Mr. Johnson, so that we're able to follow you, could you tell us the section of the bill as you're discussing it, as opposed to the section of the code?
Section Election Code 162.04. Okay.
Is that Section 4?
Yes. The other one that I found in here a long time ago, I was looking for it again, I couldn't, it forces to have joint primaries. Harris County, we're not amenable joint primaries. I couldn't find it again, but when I find it, I will let you know what section that is in. One that's really good in there, Representative Kane, that you talked about, was doing away with the newspaper postings. In Harris County, when I was in the county clerk's office doing it, it would cost us up to $100,000 to do that posting. It was 6 pages of paper because you had to list all the polling locations for every precinct. You have to list every precinct twice and the polling locations that go with it in the paper. And the Houston Chronicle required us to have that to them 2 weeks before the election. And unfortunately, many of those polling locations change. So actually it's a disservice to the voter to have it printed in the paper because it may not be accurate information by the time we get to election day. A lot of times judges can't make it, they back out, we have to combine locations, their voters will change. It's a lot better to have it online where it's real time, so if there is a change to a polling location in a and this is more happens in a primary more particularly, that would be updated immediately, and the voter would be able to get to it. We've had bills before that just suggested for this, that the newspaper post the date and time of the election and, you know, the website to go to. And they should be able to do that for free. That's 2 lines. The other one that I would say you didn't see in the bill, consider working on the county side. The early voting is actually an unfunded mandate to all the counties because they have to pay for the primary election for early voting. The state pays for election day, but the counties pay for early voting, and that's got to be more of a cost than actually election day. And I will tell you, 2 weeks of early voting is a waste of time. The first week is really not needed. You could cut that in half easily and save counties a lot of money and overhead in running early voting.
Members, any questions? Thank you.
Thank you.
Chair calls Alan Vera.
Alan Vera, Chairman, Harris County Republican Party Ballot Security Committee, testifying in opposition to HB 2640. When I was an Army grunt, standing chest deep in stinking jungle rivers, holding a rifle above the water, I wondered if any of the folks back at the air-conditioned headquarters knew what the hell they were doing. And this bill gives me the same feeling. Here are the specific items in the bill that give us a real problem. 1, we oppose allowing a party rule that could eliminate the election of county and precinct chairs. 2, we oppose making temporary state executive committee rules automatically permanent if they aren't successfully and quickly overturned at the convention. 3, we oppose allowing the state executive committee to change the ballot order of the primary ballot through a single, simple resolution, put the president at the bottom. 4, we oppose a lot of additional work and hurdles just to get a list of primary voters for the convention. We don't need that. We oppose preventing a duly elected county or precinct chair from exercising their duties because there's been a glitch in getting their names on the SOS website? Really? We are absolutely opposed to forcing county parties to hold joint primaries under penalty of not receiving compensation for the expenses of the primary. You'll do it our way or we won't cover your costs. 6, we strongly oppose eliminating the petition requirements for judicial candidates to appear on a primary ballot. Petitions are the only vehicle we have left to slightly vet judicial candidates. You take that out and we'll know nothing about the judicial candidates. Those are just 7 of the 14 vigorous objections raised by my committee and many of our precinct chairs to HB 2640. The changes made by this bill completely disregard the perspective, experience, and the realities faced by us grunts on the front line. Ronald Reagan said, "Concentrated power has always been the enemy of liberty." HB 2640 is a needless concentration of power, and we the grunts ask you to not pass it out of committee. Thank you.
Members, any questions? Representative Swanson?
Yes, thank you, Madam Chairman, and thank you, Mr. Vera, for your time coming up here.
Hope I wasn't too subtle.
It's so hard to figure out what you think.
Okay.
Do you have a spreadsheet? And also, I forgot to ask that of Mr. Johnson, if you have a spreadsheet of what you like and don't like. But so far, what I've gotten is that somebody likes Section 28, and other than that, I haven't figured out what anybody else likes.
I will send you my testimony and the references in the bill.
Thank you.
Mm-hmm.
Any other questions, members? Thank you.
Thank you.
Members, we do have Christina Atkins with the Texas Secretary of State. If anybody has any questions for that office? Okay. Anyone else here wishing to testify on, for, or against the bill? Okay. The chair recognizes Representative Cortez to close.
Thank you, Madam Chair. Briscoe said we should just vote it out right now, but I disagree. I think we should leave it pending. Members, thank you for listening, staying and to listen to all the testimony. To everybody that traveled here today and came by to provide testimony, thank you also. This is a work in progress. This is not the final bill yet, and we are still taking many more comments, questions, concerns. Please, if you have specific disagreements, and I've heard a few today, please share them with your party leadership. This is not, one party gets everything they want and the other party doesn't. This is definitely a compromise bill, and this is something we're doing to try to clean up some election code that we all agree on needs to be fixed and changed. And so we look forward to continuing working together with leadership from the Republican Party and Democratic Party and bringing the final bill with the committee substitute to the committee. And with that, Madam Chair, if there's no questions, I do close.
Okay. Members, just to clarify, there was not a substitute laid out before. And what we will be doing is leaving House Bill 2640 pending. If there's no objection, the chair hears none. House Bill 2640 is left pending without objection. The chair lays out House Bill 2982 and recognizes Representative Guillen to explain the bill.
Thank you, Madam Chair. Members, Chapter 87, Section 121, subsections G and H of the Election Code clearly state that early voting rosters must be made available for public inspection not later than the beginning of regular business hours on the day after the date the information is entered onto the roster. I've heard many complaints, however, from constituents that political subdivisions that are holding elections do not provide these rosters to the public within this time frame, and in many cases they do not provide them until after early voting is over or even after the election is over. In one particular case, after a constituent had requested the rosters multiple times over multiple days, this constituent pointed to the code that required that it be made available and was told, yeah, but there's nothing anyone can do to us if we don't. I understand that Chairwoman Click has a bill that y'all have already considered in this committee that would post and update this information online, and I think that is a big step in the right direction. What this bill does, HB 2982, simply goes one step further to ensure that this information is accessible to the public by amending the election code to create a Class C civil penalty should the clerk fail to produce the roster for public inspection. I do plan to have a committee sub that we didn't get to the committee in time that just fixes some drafting errors that I'll get to the committee as soon as I can. And I can help answer any questions if y'all have them.
Members, are there any questions for Representative Guillen? Representative Kane?
Representative Guillen, I do look forward to seeing the sub because there's been a few bills moving out that are trying to address the timely ability of people to be able to access this information. So I am curious if that sub would be able to theoretically be such a kind of a placehold. I'm not sure if some of these things are going to L&C, but I do look forward to seeing it because I think you're onto something. It seems there's been a few bills trying to address this, and they're all addressing it differently. Right. And I do see that it's a problem. And it also is troubling that a lot of people, while our code says you have to do something, if you don't do it, they just don't care. And I think some of these local entities are emboldened, realizing that they don't actually have to listen to the code.
Right.
So thank you.
That's exactly what's happening. They don't, I mean, the requirement is clearly there, but they know that there's nothing holding them to it, nothing that happens to them if they don't. So they just don't.
Thank you.
Members, any other questions? Okay. Thanks. We'll reserve your right to close, Representative Guillen. The chair calls Chris Davis.
Thank you, Madam Chair. Members, Chris Davis on behalf of the Texas Association of Election Administrators, testifying on House Bill 2982 is filed. Our members have a question on whether this bill requires that county election officers must make a hard copy available to anyone that requests it at our office during the early voting period. Of course, our offices are the main early voting polling place. We're quite busy as county election officers conducting that election. We absolutely agree that our offices must make this publicly available, ideally through, Madam Chairman, your bill, Representative Kane, your bill, posting these rosters online, but having to make them publicly available could be an issue with us. happy to answer any questions.
Okay. When you say publicly available, what do you mean?
Well, what we'd like is publicly available online.
Okay.
Virtual copies for anyone out of the comfort of their home, their office to download and view and review. But the paper copy, coming in, getting in line, taking time from our clerks and our workers, our staff that are conducting early voting at our polling place, or just managing the election can be a challenge.
Okay. Members, questions? Thank you.
Thank you.
Chair calls Ed Johnson.
Ed Johnson here representing myself. I am for, what's the bill number? House Bill 2982. Thank you, committee. This is a good bill. I agree with you, Representative Kane. You got to have some penalty in the law to have it enforceable. Back before I did elections, I used to work on lists, and I will tell you, I've seen counties play politics with the list. You know, they'll give one party the list the next day, and the next party has to get the list 10 days later from their open record request, and that's a big disadvantage in running an election. And it's I think the penalty is definitely there, because you can change the outcome of an election by withholding information in these days and times. So I think it's a good bill.
Members, any questions? Thank you.
Thank you.
Members, we have Keith Ingram here with the Texas Secretary of State's office. If anyone has questions of them. Okay. Is there anyone else wishing to testify on for or against House Bill 2982? Chair recognizes Representative Guillen to close.
Thank you, Madam Chair. Yeah, so we don't, in the bill, we don't say how they should make it available. So any way they make it available is fine. But that's if we want to be clear about it, we could be clearer, and we can make that change, get it right back to you. It's no big deal. So I appreciate y'all's favorable consideration, and we'll get you sub very soon.
Alrighty. Thank you.
Thank you.
If there's no objections, House Bill 2982 will be left pending. The chair hears no objection. House Bill 2982 is left pending without objection. The chair lays out House Bill 4545 and recognizes Representative Swanson to explain the bill.
Thank you, Madam Chairman and committee members. Currently, major election results are far easier to access than the results for smaller elections. Most people have no trouble finding out how presidential, congressional, or Senate candidates fared. In fact, it's so easy that we as voters have come to expect real-time results throughout the course of the election. Where we severely lack the information regarding election results is in smaller elections like those for independent school districts or other local political subdivisions. While not considered as high profile, local elections like tax ratification elections are arguably more consequential to voters than national, state, or district-wide elections. Keeping voters as informed as possible in these smaller elections needs to be a higher priority than it is right now. We need to ensure that election results, including how many votes were cast for each candidate or measure, are provided to promote better transparency for our constituents. Committee Sub HB 45, am I laying out the committee sub or the regular one?
The regular bill, because I don't think we knew that you had a
Okay, all right, we'll just stick to the regular one. I will say that we have a committee sub that just sort of splits it out in 4 sections, the changes into 4 sections, but nothing actually changes in the bill as far as what it does. But House Bill 4545 accomplishes this by requiring that counties, cities, and independent school districts that hold elections post the results of the election on their website, including the number of votes cast and the number of votes cast per candidate or those for or against a particular measure. It also dictates that the information has to be accessible without having to make more than 2 selections or view more than 2 network locations after accessing the website, which means that within no more than 2 clicks of your mouse, you should have access to this information. We are working on here it is right here, on a committee sub for HB 4545, which will simply create separate sections in the bill, one for counties, one for cities and ISDs. The committee sub will only require this posting from a political subdivision that currently maintains a website. It does not require subdivisions which do not currently maintain one to create or maintain a website, which is true of this bill also. This bill will increase transparency for voters casting votes in the smaller, more local elections. Thank you, Chairwoman Click and members. I'm happy to answer any questions you have, and I respectfully request my right to close.
Members, any questions? Great. The chair calls Chris Davis.
Thank you, Madam Chair. Chris Davis on behalf of the Texas Association of Election Administrators, testifying in opposition to House Bill 4545. The bill is filed, of course. The 2 clicks or less bill. We're typically, as the conducting of the election, we're typically charged and tasked with keeping and maintaining results both in hard copy form and on online as well. And we find that folks have a harder time accessing that information if the labeling, if the wording and the links are vaguely worded, not necessarily how many clicks of a mouse it takes to get to them. Our membership has a question of, will this kind of requirement apply to archived results of older elections? As elections go by, they get older. We have some counties, some of our members have election results that span decades. Will we need to make those also available within a 2-click range of the main site? That's really our concern and question. Happy to answer any of yours.
Members, any questions? Do you have questions? Representative Swanson?
I would just say that I'd be more than happy to work with you on any tweaks you feel that we need on the bill.
Thank you, ma'am.
Thank you.
Any other questions?
Thank you, Madam Chair.
The chair calls Alexei Swirsky.
I am Alexei Swirsky from Harris County. I am representing myself. I am for this bill. In general, political entities running their own elections, from my experience, need to tighten up on how these elections are run. I've personally experienced not being able to find out where to vote in an election by Cypress Creek Emergency Medical Services District in Harris County about 1.5 years ago. The where to vote was not posted on the Harris County Votes website, and I called the Harris County Clerk's office, was told they don't run the election, so they don't have power over that. I tried calling the Cypress Creek Emergency Medical Services District, and my message went to a lawyer's office, which I thought was kind of strange. I never heard back from them. I was told by the best they could figure from the Harris County Clerk's office was maybe call some fire stations in my area. I called about 5 fire stations, and the firemen seemed to not know what I was talking about. I finally found out, I didn't get to vote. It was like maybe the 3rd time in any kind of election in my 30 years of living in Harris County that I did not vote. I'm a very diligent voter. The next election for Cypress Creek Emergency Medical Services District, an informed friend that was concerned about fraud told me where to vote. I got the address. I was driving up and down the street looking for the address, finally found it. The reason it was hard to find was the only sign was a tiny sign in a window. When I went in, they were set up for voting, and I said, well, why don't you have better signage outside? They said, this is all the state requires. Needless to say, not needless to say, they could be that inept at running an election and not being under investigation, but this Emergency Medical Services District is under investigation by the FBI and has been referred to a grand jury. The turnout for their last election was 1%. Okay, I call this taxation without representation because in one of those elections a bond was up. So I'm hoping to convince Representative Swanson, and it sounded like she was talking in this direction, to include some of the other political entities in this bill. There needs to be stricter regulation of how they run the elections, that they run them in an above board and easily accessible manner to the public to even find out where to vote. Also, as an election judge and as a poll watcher, I have observed very questionable infractions of the Texas Election Code. I think the results of elections need to be posted in a very timely manner. So if somebody, a candidate or somebody that's in favor or against one of the proposals on the ballot wants to contest an election, the sooner they know the results of the election, the more timely a manner where they can get the facts and how the election occurred and whether there was any issues involved that they want to protest. So the timeliness in posting these issues is important. Thank you.
Questions, members? Thank you for being here. Chair calls Glenn Maxey.
Thank you, Madam Chair. Glenn Maxey, Texas Democratic Party, here in support of House Bill 4545. We believe that this is the icing on the cake, and I love cake icing. However, we still need a cake. And so I'm asking Representative Swanson, I dropped by your office, that we require not only the election returns, but that they simply post that the date of their election and the candidates in their election before the election. There is no requirement that that happens, and if you have internet sites that don't have election results, there's probably a 100% correlation that they don't also post that they're even having an election, the date of that election, and who the candidates are that are on the ballot. So expanding it to those items would make this a full birthday cake, and I would love it.
Representative Swanson.
Okay, that was dates of elections, candidates, what locations? Did you say anything else?
I dropped by your office.
You gave us a list of your wish list. Okay, it sounds like we need to add those things, and hopefully Ms. Swirsky can give us her suggestions at my office also. Thank you.
Terrific. Thank you.
The chair calls Alan Vera.
Alan Vera, Chairman, Harris County Republican Party Ballot Security Committee, testifying in support of HB 4545. The political subdivisions named in the bill should promptly report the results of any election they hold or facilitate, period. And we actually like the provision in the bill which limits the number of clicks to reach the results to 2. Now, we're respectful of and concerned about Mr. Davis's issues. We understand them. But on the other end of the spectrum, in the now infamous May 2014 Cy-Fair ISD bond election, it took 17 clicks for the voters to find any information on mail ballots. And when they got there, it referred them to the county clerk who wasn't running the election. So making it easy for the voter to navigate and find this page should be a critical part of this bill. We don't think the subdivision should have the option of having or not having a website. We think they should be forced to, but that's for another time. We support the bill as is. Thank you.
Questions, members? Representative Busey.
Thank you, Madam Chair. The 17 clicks, was that even like right after the election it took that long, or was that like archived results much later?
Representative Busey, it was actually leading up to the election.
Okay.
Voters, elderly and disabled voters, were coming to find out how they could vote a mail ballot in the Cy-Fair bond issue, and it took them 17 clicks to get to it. Then they got to it and were transferred to the county clerk who wasn't even running that election.
Yeah.
So out of 151,000 votes, because I was a poll watcher in Central County at Cy-Fair, there were 12 mail ballots. It was ridiculous.
Thank you.
Mm-hmm.
Thank you, Madam Chair.
Other questions, members? Thank you. Chair calls Ed Johnson.
Ed Johnson, here representing myself, and I'm for the bill, House Bill 4545. Great bill. I just had personally trying to do my own little city election and took me 2 weeks to find out in my own city. I live in a very small little city. When the last time they had an election was. Had to do an open record request and dig into the archives and all kind of stuff to actually find it because they didn't even have any of it online. It's good. Working in the county clerk's office, we would get numerous phone calls all the time asking, where are the results of this election? Where can I find them? Stuff like that. We would just have to say we don't know. When the entities conduct their own elections, they keep that and they do it. I heard one person one time talk about a mud district election where they posted it on the back of the water tank and you had to crawl the razor wires to get over it to see it. It's just ridiculous. So it's something that needs to be addressed. I would agree with Glenn Maxey. If you can put more information about the election on their website, they should.
Any questions, members? Thank you.
Thank you.
Members, we have Keith Ingram with the Texas Secretary of State's Elections Division here. If you would like to ask any questions of them. All righty. The chair recognizes Representative Swanson to close.
Thank you, Chairman Click and members. And I thank everyone who came forward and gave their suggestions. I would ask all of you to please get your list to my legislative director in the next day or so, and we will work on a committee sub that covers all these things. They sounded like a lot of good suggestions, and with that, I close. Thank you.
I think Representative Busey has got a
just
comment
real
or question.
kind of a comment or observation. Thank you, Madam Chair. It seems to me that if I understood correctly, what Chris Davis was talking about was the issue of all the archived results and having to keep all that up front. So maybe there can be a committee sub that has like the most recent election for a certain amount of time, and then the rest could maybe be more than 2 clicks away. I don't know if that would satisfy what you were hoping for. But that was why I asked the question about was that at the time of the election when Mr. Vera was talking or not, because it seems that I guess I think it's a really good bill. I think what you're trying to do is great. It just seems I can understand the issue with archives and having to have that in deeper places, but maybe that's an idea.
I totally agree. So I'm asking each one of them to just get your suggestions in the next day or so to my legislative director, please.
Thank you, Madam Chair.
Thank you.
If there are no objection, House Bill 4545 will be left pending. The chair hears no objection. House Bill 4545 is left pending without objection. The chair lays out House Bill 4082 and recognizes Representative Middleton to explain the bill.
Thank you, Madam Chair. Members, today I'm laying out House Bill 4082. House Bill 4082 addresses the internal structures and operations of political parties, and those are currently heavily regulated by Texas statutes. Both major parties have suggested that they should be allowed greater flexibility in how they manage their own internal structure and organization, and that party operations should be in each respective party rules and not in our state statutes. House Bill 4082 amends Section 163.003 of the Election Code to give political parties greater flexibility in how they choose to function by party rules as private, non-governmental entities. This bill would allow political parties to manage their own internal affairs in areas that do not directly affect non-political party-related state law or citizens' rights. House Bill 4082 does not affect the management of primaries for political office, who can access a party's primary ballot, or who can vote in a party's primary. This bill was brought to me by my SRIC committeeman and the chair of the Republican Party of Texas. Both are here to speak more on this legislation, and I would defer to them on any technical details or more specific questions about how these laws would work. I now yield for questions, and I reserve the right to close. Thank you.
Members, any questions? Chair calls James Dickey.
Good morning, Madam Chair, members. Yes. My name is James Dickey. I'm chairman of the Republican Party of Texas, and I'm here on behalf of the party testifying in favor of House Bill 4082. The Texas election code micromanages a startling amount of details on how the political parties in the state function. Here are just some of the things that Texas law dictates. How many people are on our state executive committee, what their districts are defined as, their terms, when they're elected, whether or not a county executive committee can allow proxies, how many proxies the state executive committee can have, how often we have to have our conventions, and on and on and on. As a result of all that detail, you all have seen House Bill 2640, most of whose 55 sections are necessary to make changes to items like the above. We support the Democrat Party's request to do things like organize their state EC by congressional district instead of senatorial district, for example. But more importantly, we support House Bill 4082 and the related 4083 so that such changes in the future would not require a change to the election code or the agreement of both major parties. Each party would be free to organize as its own rules see fit appropriately. The question is not what those particular decisions should be, but who has the right to make those decisions. And it is our strong belief that the parties have the right to make those decisions. In talking things over with folks on the Democrat side, they pointed out that it would probably be wise to modify this to exempt sections 172 and 173, which do have some, which relate to operation of the primaries and some things such as filing fees, right? And that seems perfectly logical, and I've not yet had the chance, I just got that and have not had the chance to speak that over with the author, but I am sure that with a couple of minor changes like that, this is absolutely a principle that we can all agree on, that governs best which governs least. And HB 4082 is a great example of doing exactly that and doing it well. There have been a lot of folks who talk about how this would change everything, and the reality is it would change nothing. It would recognize in state law that we are private entities with the right of freedom of association and self-governance. It would retain everything that is currently in the code as the defaults. And so then the parties would be free to determine and through orderly process decide if and what might need to be changed and how to change that and how to do it. More importantly, it would allow us to respond more quickly than we're able to do so now when we have to wait 2 years for session to change things. So I encourage you to vote in favor of this bill.
Thank you, Madam Chair. Mr. Dickey, thank you. And I think you may have just hit on it when you said potentially looking at exempting Section 172 and 173.
Correct.
That would be dealing with the primaries, would that deal with when primary dates are?
Correct.
Okay, so you're...
That would exempt that. That is clearly a joint activity that it would get problematic if the individual parties started to change all that up.
Sure. I think some of my concerns were tied to that it would we might have different primary dates or
Correct.
different rules for who gets to run. But
Yeah.
you'd be okay if that got changed. You would say that this would really be dealing with party administration, party leadership.
It's party structure, conventions, those kind of things.
Okay. I appreciate it. Thank you. Thank you, Madam Chair.
Other questions, members? Thank you.
Thank you.
Chair calls Glenn Maxey.
Thank you, Madam Chair and members. I am Glenn Maxey with the Texas Democratic Party. I registered on the bill. I'm passing out two things. The bill talks about rules under this title. This title is Title 10. So in this handout, I give you from the election code everything that's in Title 10 that deals with political parties, and then a suggested language for a substitute. I believe that, as Chairman Dickey just said, that chapters 172 and 173 should be exempted. Otherwise, the Democratic Party will pass a rule that say Republicans have to pay a filing fee twice as high as and there would be a lot of havoc. Secondly, that I believe that we should say that the rules under this should be have, just like statutes have an effective date, that we adopt rules before an election cycle so that nobody's doing rules in the middle of the stream and changing processes while they're ongoing, so that any kinds of rules that were overriding the election code should be done perhaps on January 1st of the even numbered year to be effective past that time. And lastly, because we don't sort of know where this will head in adopting rules on party affairs, I don't want to get to a situation that any rule that the Republican Party adopts or the Democratic Party adopts indirectly ties the hands of the other party by making something happen. So I think we should spell out very clearly that this is rules for their party, dealing with their party affairs, and not even indirectly through how we do things tie the hands of the other party. And with those things, we would be very happy to have the flexibility for the Democratic Party and the Republican Party to make their own decisions about party affairs.
Questions, members? Mr. Maxey, how do you envision, if this were applied, that members of the public or people that wanted to participate in the process would learn about those changes?
Well, I had proposed in House Bill 2640 that we allow party rules to say about how we post information about party rules, because right now the law says party rules have to be filed with the Secretary of State, and then any change during the cycle has to be filed if the state executive committees adopt rules. And I asked Keith Ingram, has anybody ever come to the Secretary of State to look at those rules that are filed there? And he said no. And so I sort of knee-jerk said, let's take them out. Now, if we were going this direction, I think that those rules need to stay in place. So there is one place to go find the rules and any changes to the rules. I do think right now, anybody who wants to know how the election code is done or party affairs that are mandated through the election code can go look at the election code. And here you're going to have to be balancing election code versus Democratic rules, Republican rules. And so they need to be posted on the party's website clearly and perhaps on the Secretary of State's website, or linked on the Secretary of State's back to the party's website. So there is an online place to find the processes and procedures.
Members, any other questions? Thank you.
Thank you.
The chair calls Russell Hayter.
Thank you, Madam Chairman, members. Russell Hyder, I'm with the Hays County Republican Party. I'm the chairman. I'm testifying against 4082 on behalf of myself. Just generally, I want to say, don't California our Texas. Generally, this is the way I see it. The established law that we have on the books right now has been there for a while. Everyone is accustomed to it, used to it. We know the rules. We know how it works. We don't need to introduce a change from one regime to another in party politics. If a person gets involved in a party and becomes a chairman and gets a structure in place, and then all of a sudden they're gone at the next convention, and somebody else comes in and wants to change everything again, they can do that under this bill. That's detrimental to the process. It's confusing to people, and I don't think it's a good thing. The party rule should not be in conflict with state law. Delegates, you should not delegate the legislative duty to an unelected body. This bill opens the door for some of the same type of concerns that we have about 2640. We should not eliminate the normal grassroots voters from the political process. When you remove the guardrails on a dangerous highway, traffic can meander all over the place, and I think that's what this bill does. Please don't vote it out of committee.
Questions, members? Thank you.
Thank you.
Chair calls Alan Vera.
Alan Vera, Chairman, Harris County Republican Party Ballot Security Committee. While we are in line with the spirit of the bill, we are right now testifying in opposition to HB 4082 because of lack of specificity. Basically, the bill allows a political party to adopt a rule or rules that allow it to conduct its electoral affairs in a manner inconsistent with TEC. Okay? Most of us assume the best. Oh, they must be talking about caucuses or conventions or some other way. But the bill doesn't place any brackets. So my party wants to have raffle tickets, and the winner who sells the most tickets gets elected. It seems silly, but there have been some rogue county parties out there where that might not be so far-fetched. Also, if we begin changing how things work in the Electoral College, we have to educate the voters a lot. And people who are used to going to vote in a primary every time, if that changes, I don't know how we get the word to those people and what kind of effect we have on their confidence in the system. Now, if you support the bill generally, if we can put brackets around just how far we can go in changing the rules, there's another concern we have to address. There is wide variation in the size and complexity of our county parties. Okay? The bill only uses the word a political party, and we're not sure yet if it applies to state or local. But if that means state party, then the bill should allow provisions for the county party to continue to follow TEC if it prefers that over the new direction. Okay? This is a mess, okay, and I apologize for it, but I think we need to bracket this thing. We prefer the bill allow the county party to continue to follow TEC if it comes to that. I think we can work something out that can put us in support of the bill, but currently it's so vague, we're not sure what is going to be the outcome. Thank you.
Questions, members? Chair calls Alexei Swirsky.
Alexei Swirsky, Harris County. I was going to register in favor of this bill, but I have come to greatly respect the wisdom and experience by Alan Vera. I appreciate the spirit of the bill. And this is what I have to say about that. All politics is local, as the late Speaker of the United States Congress, Tip O'Neill, once observed.
Ms. Swirsky, your position on the bill?
Neutral.
Okay. So you need to... Okay, thank you. Go ahead.
When functioning properly, political parties help place citizens' local concerns in a national context. The state of Texas is considered a big player on the national political scene. What we do here in Texas affects the nation. It is imperative that each political party in Texas be free to operate under its own rules as determined by those within each party, and I believe that's what Mr. Middleton is seeking to do. The parties are then free to seek the principles and policies they think are best rather than be dictated to by the government. So in general, I'm in favor of what you're trying to do with this bill. I would just ask you to work with the concerns outlined by Alan Vera. Thank you.
Questions, members? Thank you. Chair calls Eric Opiella.
Howdy. Eric Opiella, testifying on behalf of myself against House Bill 4082. The bill, as it's currently drafted, turns Texas election law on its head by taking party rules and making them supersede what the election code says. Article 3, Section 1 of the state constitution vests the legislative power in the legislature, and prior enactments doing similar things to this have been struck down by the state Supreme Court as unconstitutional because you're vesting that legislative power over elections, conventions, and the process is fundamental to the ballot in the hands of a private unelected body. Political parties would be free to set up their own rules governing primary election ballot access because Title 10 covers, as was pointed out by prior speakers, not only the internal administration of the parties, but everything concerning the parties, including the primary dates, the primary ballot access, the designation of party nominees, the ability to vote in primary elections or participate in primary conventions at any level. I also want to be clear that not only would you need to exempt 172 and 173, you'd also have to exempt Section 1 or Chapter 174 from this as well, because that governs a convention process. And the convention process is where our presidential nominating process is really vested in the election code. So we have a section after this that talks about how we set up our presidential primary. But the delegates to the national nominating conventions are selected at your conventions, all the way from the primary all the way up to the state convention. The electors, as was pointed out by a prior speaker, are selected at your convention process as well. When you open up the lockbox that is in the election code right now that protects the rights of the party's members, and keep in mind the party's members are very important here. Those are the people who vote in the primaries in each political party. When you take away those guarantees included in the election code, which guarantee them the right to choose their candidates, to participate in the process or elect nominees, especially for the most important office that we ostensibly vote for every 4 years, President of the United States, and place it in the hands of two unelected bodies potentially, which is what this bill would do, you would have the unconstitutional effect of undermining the free speech and associational rights under the federal Constitution. And these are things that are also in the Republican Party platform. Platform Principle 1 this bill would violate, and Platform Plank 199 would also be violated, guaranteeing free and fair elections. Because this bill also eliminates the ability for a candidate or a voter to enforce party rules in the courts by writs of mandamus if they're violated. In the time-sensitive election process, this would eliminate a key judicial check on the process to make sure that everyone has a free and equal chance to participate in the electoral process. Happy to answer any questions.
Members, questions? Thank you.
Thank you.
Chair calls J.T. Edwards.
Good morning again, Madam Chairman, members. J.T. Edwards, representing Galveston County Republican Party. I'm also an SREC, and I am testifying for the bill.
And on behalf of?
On behalf of Galveston County Republican Party.
Thank you.
I'm going to get this down, Pat. Thank you, Madam Chairman. And I thank Representative Middleton for bringing this bill to this committee. So as I referred to in earlier testimony, first things first, I think we all agree that the Texas Election Code needs work. I think we can all agree with that. Second, there's a preceding bill in 4083 that actually allays some of the concerns laid out in earlier testimony by defining electoral affairs and party affairs, which is not clearly defined right now in the election code. It's just the election code, and you go to conventions, and you vote this way. And this is how political parties organize and perform its business. This bill, 4082, clarifies and allows, as Chairman Dickey earlier testified, private associations, that's the political parties, to go about and conduct our business. Actually, there was a writ of mandamus in Natchez County, 2008, in which the Third Court of Appeals, and actually I forgot to bring my copies early morning, Galveston, trying to drive here, and I'll provide that to the committee as written testimony later. But in the writ of mandamus, as they were trying to sort out things regarding party rules and the like, the court said that as a private entity, or alluded to in its decision, said that as private entity, your rules apply. This law, currently right now, allows Democrats and Republicans and whoever else to go about and conduct its business, as it sees fit. And so with some concerns about guardrails and the like, I think it's just a matter of trusting your entities, by the way, the SRECs, the county chairs, the precinct chairs are elected. I'm elected at convention. County chairs, precinct chairs are elected in primaries. So I find that a little misleading, if I may, to say we're giving legislative power to people who are not elected. That's not true. So with that, I really ask for your favorable consideration. I think this is going to help both parties in general, and they'll do a lot of cleanup work as well. And I'll be happy to answer any questions you may have.
Members, any questions? Could you expound upon the litigation you were talking about?
Sure, not a problem.
As to what the facts.
Yeah, the facts are a delegate wanted access to a list of delegates for a convention. She had to file against the county chair to writ of mandamus. That mandamus was heard in Third Court of Appeals in Natchez County, and then it was also appealed to the Texas Supreme Court. And in that, and I'll be more than happy to provide. It's actually a pretty simple read, but in that decision by the Third Court of Appeals, clearly pointed out that the political parties, their rules, pretty much when it comes to self-determination or self-discipline, that's not in the jurisdiction of the courts, but that's in that particular party itself. And I'll be able to provide that, in fact, as soon as I get back to my phone.
That'd be great if you could, provide the members
I'd be more than happy
a copy
to.
of that. We would very much appreciate it.
Thank you, Madam Chairman.
Any other questions?
Thank you for your
being
favorable
here.
consideration. Thank you. Thank you, Representative.
Chair calls Joe Poyman.
Madam Chair, members of the committee, my name is Dr. Joe Poyman. I'm Executive Director of Texas Alliance for Life, and we are opposed to this bill. We typically don't get involved in election issues with a couple of exceptions. When one exception is when there's inadequate transparency for voters to know who's financing elections. Voters need that information to decide who's trying to influence elections. Another thing is when the power of voters is being taken away. Power from voters is being taken away, and that is really possible with this bill. We don't know what the rules would say that supersede election law, but one obvious possibility is that the SREC or SDEC decide who's eligible to be on a primary ballot, whether their views are consistent with some platform or statement of principle or something like that. In our view, that's an end run around voters who should decide whom to nominate for the general election from each party. We should not place that power in a small number of some executive committee. Now I point out the SDRC and SDEC are elected not by voters, they're elected in caucus. Those elections are not public, so their expenditures, their campaign contributions are not made public. So the public has no way to decide whether because of this lack of transparency, the public has no way to decide whether there's fraud or bribery going on with this small number of people who are deciding potentially who is fit to run on a ballot. Members, we oppose this because we should leave this matter up to voters. We have a process whereby a primary, any number of people can sign up and put their name in, raise money, spend money. That's all public, and that is a very good process, which I think has gotten very good results. We're weighing in Texas Alliance for Life not as a partisan issue, but because we cannot pass good laws, as have been done by this legislature over the years, without the right people here. And those people are here because they were elected by voters. Thank you.
Members, any questions? Thank you. Chair calls Sam Bryant. Going once, going twice. Members, we have Christina Atkins as a resource witness if anyone has any questions. Seeing none. Is there anyone else wishing to testify on, for, or against House Bill 4082? Seeing none, the chair calls on Representative Middleton to close.
Thank you, Mr. Chair. We have some good suggestions here today on some clarifications and improvements, and I keep working with stakeholders to make this a better bill. And with that, I yield for any closing questions, and I close.
Thank you. Members, any questions? Chair sees no questions. We're going to go ahead and leave House Bill, if there's no objection, leave House Bill 4083 will be left pending. Chair hears, I'm sorry. Okay. There's no objection. House Bill 4082 will be left pending. Chair hears no objection. House Bill 4082 is left pending without objection. Sir, you still have the floor, so the chair lays out House Bill 4083 and recognizes Representative Middleton to explain the bill.
Thank you, Mr. Chairman, members. I'm laying out House Bill 4083, and basically all this bill does is it codifies the definitions of electoral affairs and party affairs of a political party, which are currently not defined in the code. By defining these terms, this is really enabling legislation for House Bill 4082, which we just heard, and I defer to my colleagues with the Republican Party of Texas with any technical questions regarding these definitions. And with that, I yield for questions and reserve the right to close.
Thank you, Representative. Members, any questions for Representative Middleton? Seeing none. The chair calls James Dickey to testify. Please state your name, who you represent, and your position on the bill for the record.
Yes. Good morning. Madam Chair, members, guests, my name is James Dickey, Chairman of the Republican Party of Texas. I'm here on behalf of the party speaking in favor of the bill. My sincere thanks to Representative Middleton for putting this forward and for catching that the law had not defined these terms, and so it led to concerns like the misunderstanding a moment ago where someone was talking about this affecting general election or even primary election ballot position and placement. And these definitions are important for making very clear, especially along with the exemption of 172 and 173 in House Bill 4082, would make it really very clear that we were talking about internal operations for the party, not general election efforts. I ask you to support the bill.
Members, any questions? Thank you.
Thank you.
Chair calls Russell Hyder.
Madam Chairman, members, thank you. Russell Hyder, Hays County Republican Party Chairman. I am here to testify against House Bill 4083. This is basically another bill that opens the door to making the election process more like California.
Mr. You're representing yourself,
yes,
is that
ma'am.
correct?
Representing
Thank you.
myself, yes, ma'am. We should never allow anything that excludes such large sections of average voters. There's a concern that this could disenfranchise rural voters in favor of urban voters. Whenever you open the door to just changing party rules from one regime to another, then you lose the certainty that you have with the things that are in the election code that are vetted by the legislature and actually by representation all the voters of Texas. So I ask you to keep this in committee and not vote it out. Thank you.
Members, any questions? Thank you.
Thank you.
Chair calls Glenn Maxey.
Glenn Maxey, Texas Democratic Party. I registered on this bill, and because I didn't quite understand why we were doing it, and I still don't, but so I'm just going to shut up.
Chair calls Ben Broughton. Okay. Chair calls Alexei Swirsky. I think we still need for you to come up.
Just because she said she passed. I'm sorry.
We still need for you to come up to the microphone and sorry.
Okay, I'm in favor of this bill, and I appreciate that Representative Middleton's efforts to clarify things in the election code. Just want to make sure it's laid out so we have very clear law. Thank you.
Okay, and you're representing yourself?
I represent myself.
Thank you very much. Chair calls J.T. Edwards.
Okay, I'm going to get this right this time. Good morning, Madam Chairman. Members, my name is J.T. Edwards, representing myself for the bill. Doing good so far? Nope. I still messed it up.
Okay.
Galveston County Republican Party.
And that's
Thank
who
you.
you're representing?
Yes.
Thank you. Okay.
It's early morning, 3 a.m. from Galveston. Real fast, in the interest of members' time, so thank y'all so much for having me and serving the great state of Texas. These are the definitions I spoke about. The election code has not defined these definitions, and I think this addresses and allays a lot of the concerns you heard in earlier testimony. And with that, thank you, Representative Middleton. I ask the committee for favorable consideration. Thank you so much. I'm available for any questions.
Questions, members? Thank you.
Thank you.
Chair calls Eric Opiella.
Eric Opiella again, testifying against House Bill 4083, representing myself. This bill, while billeted as a cleanup bill defining terms that are not defined in the election code, actually is not a cleanup bill. It, first of all, defines a term contradictory to another definition of electoral affairs that's already in the election code. The election code already does define electoral affairs in... Give me just 1 second. I will pull up the section. It is Section 163.004 of the Election Code. Electoral affairs is currently defined as anything governing or affecting a general or runoff primary election, conventions held under this code, or nominees. This would set up a scheme where you would have one definition in Section 1 of the Election Code, the general definition, which would contradict that the definition that is the specific definition, which is located in Section 163.004. Under the rules of statutory construction, the specific governs the general, and so this bill would have no effect in defining electoral affairs as the operation of a party. Moreover, it attempts to define party affairs, a term which does not appear in the election code. Party affairs only appears in the election code within two captions to other sections of the code. The actual term party affair does not appear anywhere else in the election code and does not appear in any substantive law. But what this will do is cause confusion among what is actually included in electoral affairs. So currently, electoral affairs is any matter governing the administration of elections. But defining the term party affairs as party affiliation being taken out of electoral affairs would then create the confusion and potentially allow a party to create rules governing affiliation with that party that is outside of the election code's requirements for the definition of affiliation under electoral affairs. So I don't want to belittle the bill, but I do think there is a lot of work that needs to be done to the bill to make it conform to the actual election code. One, because the definition of party affairs does not define a term that's in the election code. And then secondly, it would create an inconsistent definition because now we'll have two different definitions of electoral affairs. One in 163.004, and now one up in the definition section. And so that's why I think some of the commentators said, what's the point here? Happy to answer any questions.
Representative Burrows?
Yeah, I do. I mean, it seems like you could fix at least the first concern fairly easily by just saying electoral party affairs are actually making the terminology different, the nomenclature. Mm-hmm. I mean, that certainly solves it, right?
Well, here's the problem. If you change the definition of electoral affairs to be what this bill says,
No. What I'm saying is actually in the bill itself, change the word, the nomenclature used to define electoral affairs to say, call it something different. We simply say electoral party affairs. I mean, it's real simple. Add a word into it, and we can change this and fix that first concern fairly easily.
we could definitely do that, Representative Burrows, but the problem is then that term is not actually used in the election code, so the definition's meaningless.
Okay, but it's used later on in party affairs. So really the issue is, because it's used right here, electoral affairs. So we could change that, make those two marry up. So the real question is, what does party affairs mean, and is it necessary in there?
And it's not in the election code right now. And so if we were
just
to
in captions.
Yes, if we were to change that, and the law of the state is that captions are non-substantive and are not the law.
Okay.
And so at this point, we would have two definitions because we just created one of a term that does not exist in the election code, and then we have another one of a term that only exists in captions. So again, we create confusion among people as to what exactly the party has power over and what does the election code govern.
All right.
I'm sorry, but it would still be a meaningless bill.
Okay. Well, I'm just trying. I heard your testimony. I just wanted to think it's pretty easy to at least fix the first concern that you talked about.
Absolutely.
All right. Thank you.
Thank you.
Members, any other questions? Thank you.
Thank you.
Members, we have Christina Atkins with the Texas Secretary of State's office here. If anyone has any questions for her. No? Okay. Is there anyone else wishing to testify on, for, or against House Bill 4083? The chair recognizes Representative Middleton to close.
Thank you, Madam Chair, members. With that, I close on House Bill 4083. Thank you.
If there's no objection, House Bill 4083 will be left pending. The chair hears no objection. House Bill 4083 is left pending without objection. The chair lays out House Bill 4416 and recognizes Representative Middleton to explain the bill.
Thank you, Madam Chair, members. I'm laying out House Bill 4416. And currently, a political party can have its nominees placed on a general election ballot in two different ways. One is by circulating a petition and getting approximately 50,000 signatures to be on a statewide ballot covering all 28 million Texans. The second and most common way a political party accesses the ballot in a general election is by fielding a nominee for a statewide office who received a number of votes equal to at least 5% of the total number of votes received by all candidates for that office in the previous election. This is a low threshold that allows parties that do not have a full slate of candidates or significant electoral support access to the ballot. House Bill 4416 raises this threshold from 5% to 10% to ensure that only parties who are able to field a robust slate and garner significant support are able to earn being placed on the ballot. The Democrat and Republican parties have real voter outreach that is not just reliant on monetary resources. Both major parties run primary elections to get on the ballot and have a very high level of voter input to get on the ballot. It is not unusual to knock on thousands of doors, as many of us on this committee have, when you're running to be a party's nominee, which is exactly what it should be about when you're running to represent thousands or perhaps millions of people. Some of the minor parties, on the other hand, have almost no voter input, conduct no voter-driven primary election, and select a nominee often with just a couple of dozen people at their district convention. Raising this threshold from 5% to 10% to earn the qualification to be on the ballot does not exclude anyone. Many diverse states have a higher threshold for a party to automatically qualify for the ballot access. Georgia and Alabama, it's 20%. New Jersey and Virginia, it's 10%, and Florida has a very high bar as well. Still, this does not limit access of individuals to the ballot at all. One may run as an independent with a petition of 1% to 5% of the number of voters from the previous governor's election depending on which office you're running for, or as a write-in candidate with either a filing fee or with a petition with 2% of the number of voters from the previous governor's election. House Bill 4416 will ensure that committed candidates are on the ballot and that our ballot reflects parties that can earn substantial electoral support. With that, I yield for questions and reserve the right to close.
Members, any questions? The chair calls Jennifer Hall.
Madam Chair, members, thank you for this time this morning. My name is Jennifer Hall. I'm speaking against HB 4416 on behalf of myself. I understand that there needs to be a threshold for a party to be on the ballot. After all, ballots could get long and confusing if we didn't have some type of threshold. However, I believe it's wrong on principle for either of the major parties to attempt to limit the ballot access by moving the goalpost because third parties have been able to get on our ballot. Additionally, the main reason I'm here, I'm a mother of 4 boys, all in their 20s now, and a couple of them regularly work elections as either election judges or clerks, and I have one that has served on the ballot board quite a few times. I tell you that to give you a view of their political involvement. One of the common topics of discussion they have with their friends at our home is how difficult it is for third parties to compete, how it's kind of controlled by the Republican and Democrat parties. My concern is that right now they vote, they encourage their friends to vote, but if they see the parties attempting to stifle competition, it's likely they and their friends will lose faith in the process and potentially stop voting altogether.
Members, any questions? Thank you. Chair calls Kathy Glass.
Madam Chair, honorable members of the committee, I'm Kathy Glass. I'm chair of the Harris County Libertarian Party, testifying on behalf of that organization and myself in opposition to this bill. This particular this particular provision, Section 181.005, that is sought to be changed, was only enacted in 1985. So how did third parties get on the ballot before then? And we did. I have to correct Representative Middleton that there are only 2 ways to get on the ballot, the petition and 5%. No, there's a third way, and it's the same way your candidates get on the ballot. It's getting 2% in the governor's race. Did you know that? Now, where in the election code does it say that if you get 2% in the governor's race, you automatically get on the ballot? I haven't found it. It's not there. Yet, how do you get on the ballot? You don't get the provision of 181. You don't get the protection that 5% doesn't apply to you. So how do your candidates get on the ballot? And it's because, historically, it's very complicated. But the Secretary of State has created a rule that lets you get on the ballot with 2% in the governor's race. Now let that sink in. That some political appointee, elected by no one, voted on by no one, gets to decide the rules for how your party and ours get on the ballot. Because that applies to all parties. Now, if this, when is the last time any third party got 10%? That's a measure of, is this a realistic goal or not? When is the last time in a contested race with a Republican and a Democrat both on the ballot, that is, it's not vacant by one of the 2 major parties, when is the last time that has happened? You'd have to go back 50 years to the early 70s, the La Raza Party. They were a flash in the pan, but they had one success. And since then, it has never happened. So that is how unrealistic and oppressive this suggested change is. I have to say in response to Representative Middleton, that we don't run active campaigns. No, I ran for governor in 2014. I visited all 254 counties. I spent $250,000. I handed out 10,000 yard signs. I don't know how many leaflets. And I got major coverage in almost every county and in every major market except one, Sherman. Never could get coverage there. I ran a more active and visible campaign than your nominees for governor did. And I won't, so I have to correct that. Now, in 1982, I was the Libertarian Party's first nominee on the ballot for Attorney General, and I got over 2% of the vote. Our gubernatorial nominee did not. So we couldn't get on the ballot because the Secretary of State said we didn't meet that office's created 2% rule. We filed suit over that. We lost. And then we came here to the state legislature seeking the same relief. As a result of that effort, that's how we got Section 181.005, the 5% rule. But we didn't lose the 2% option for governor's race. Now, if this bill passes, and if a lawsuit ensues, I would suggest to our party that we make a focus of that lawsuit then what we should have done back in the 80s, and that is question the legitimacy, the power of the Secretary of State to create rules for how people get on the ballot. It's too important. And what would that do to your nominees? If a court ruling is that that's not effective, you can't get on the ballot because the Secretary of State made up a rule when we got an election code. So where would that leave us all? We'd all be in the soup. It's kind of mutual assured destruction. So let's not stir up that hornet's nest. Let's focus on what we need to do, and that's clean up the election code, including making it clear that a non-elected political appointee, one person, never voted on by anyone, can set the standards for something so important to our state as how you get ballot access. Thank you very much. That concludes my remarks.
Questions, members? Thank you. Chair calls James Dickey.
Good morning, Madam Chair and members. I'm James Dickey, Chairman of the Republican Party of Texas, representing the party speaking in favor of the bill. I'm very sensitive to the concerns about being perceived as piling on or overreaching, and in talking with folks, no question there would be some percentage at which it would be completely unreasonable to do such a thing, given the numerous other states that have higher thresholds than the 5% that we have, and given that we're still talking about 90% of people voting for others, I believe the 10% level is a reasonable threshold, and I ask you to vote in favor of the bill.
Members, any questions? Thank you. Chair calls Stephen Haskett.
I'm Stephen Haskett. I'm representing myself in opposition. I drink Dr. Pepper, and this seems to me like Pepsi and Coke trying to decide how much shelf space Dr. Pepper gets in the retail store. I've run on the Libertarian ballot here in Travis County in a slate that was not filled by the Republicans. I earned 69,000 votes in the county. The only reason I was able to run was because the Libertarians have ballot access. And maybe we're just the none of the above vote, but it's a vote that in order to get on ballots, We don't do the, as you point out, excuse me, I'm nervous, which is unusual for me. I'm passionate is the word I was looking for. I'm passionate. We don't get to run in the primaries. We do everything by convention. You're right, those turnouts can be small. But those are people that are motivated to take not 1 day off, not 2 days off. We have to go to precinct, county, district, state, and federal conventions to get people on the ballot. So this means people are taking multiple days off and coming into town multiple times in order to do this. And these are based on the rules that you guys set already. That's not necessarily the way we would do it if we had the choice. So I do want to point out that I could be persuaded to support this bill. I think the threshold could be raised to, say, 90, 100, 101% to get on the ballot, and I would be able to support that. But doing this is clearly a shot at the party that I'm a member of by setting it at from 5%, which we've achieved over several years, many years, to 10% on a statewide election. In my election, I got much more than 10% of the vote. So when we're talking about averages over state elections, but the ballot access goes all the way down. So I'd like you to consider that. Thank you.
Members, any questions? Thank you. Chair calls Sean Huckabee.
I'm Sean Huckabee, Secretary of the Libertarian Party of Bexar County, speaking on behalf of myself against House Bill 4416. Throughout most of human history, man has lived as a subordinate to other men. Slaves were the property of subjects, and subjects were the property of kings. Men as property was the norm, and liberty was always the exception rather than the rule. This changed during the Enlightenment. Ideas that we take for granted today, such as individual rights, democracy, and governments being instituted among men to serve the people rather than autocrats, started to spread, ultimately culminating in the Declaration of Independence and the formation of the world's first true representative democracy. The right of the people to select representatives that serve their interests is the cornerstone of both the federal government and the government of Texas. Any law that impedes this is an affront to the core foundational values of our government and an affront to the liberty of every Texan. Texans have the right to as many options as is feasible on their ballot. The current 5% requirement is itself already too strict and limits Texans to 3 options on the ballot: Republicans, Democrats, and Libertarians. No reasonable case can be made that having 3 options on the ballot is such a burden on the state of Texas or its people that we need to make it more difficult for anyone outside of the 2 major parties to be on the ballot. The motivation behind this proposal is clearly political. The purpose of this bill is not to serve the people of Texas, but to serve the interests of politicians that operate within the 2 major political parties by making it more difficult for anyone to run against them. I implore any and all members of the House that still believe in liberty and democracy to oppose this bill out of principle. Thank you.
Members, any questions? Thank you. Chair calls Nathan Kinman.
Good afternoon, Chair, members of the committee. My name is Nathan Kinman. I'm from Harris County. I'm representing myself. I just wanted to say, my years of voting, I've always voted for the person I felt shared most of my convictions. Sometimes as a Democrat, other times a Republican, other times as a Libertarian or an Independent.
In your position on the bill?
I'm against this bill.
Okay, thank you.
And as the previous people point out, that this is definitely a clear shot on the voters. When I go to a restaurant, I like to look at a menu. I like to see a variety of things on that menu. Likewise, when I go vote, I like to see a variety of candidates. And I, as an individual voter, do not appreciate being limited to having to vote lesser of two evils. And I think, I'm sorry, I'm just a little nervous. I don't really do this every day. Basically, my point is that you people are supposed to work for us. We do not work for you. That's something you need to remember. And that's all I have to say. Thank you.
Questions, members? Thank you. Chair calls Anastasia Williford.
Hi, my name is Anastasia Wilford. I am the Operations Director for the Libertarian Party of Texas, representing myself in opposition to this bill. A couple of things that I do want to clarify. As Representative Middleton pointed out, there are approximately 4 states in the U.S. with more restrictive ballot access laws than Texas. That makes us number 5 out of 50. There are numerous states where less restrictive ballot access laws have actually been struck down as unconstitutional violations of our First Amendment rights. And so doubling this requirement from 5% to 10% is just asking for trouble. Secondly, he stated that in order to get on the ballot, a party can collect 50,000 signatures. However, after the 2018 gubernatorial race, that number is actually increased to 83,434. Almost every state that has a petition ability for a candidate or party to get on the ballot has much lower thresholds, from 2,000 to 5,000, many of which actually have a maximum requirement as well. However, in Texas, we have none. So what this bill is actually going to do is it is going to limit the ability of Texas voters to express their either satisfaction or dissatisfaction. It is going to decrease our freedom of expression, and it's going to decrease competition. And I think that if we look at, you guys are on a committee. I've worked on several committees myself. And one of the best things about a committee is bringing together people with numerous different ideas and coming to a compromise that we can all work on. Not everybody gets everything that they want, but bringing more ideas to the table is beneficial. And I think that having numerous parties on the ballot will actually allow Texas to thrive more than we already are. Thank you.
Members, any questions? Chair calls Eric Opiella.
Chairman Click, members, Eric Opiella, representing myself on the bill. I just want to point out that every election cycle we have a different number of people that run for the statewide offices. While back in 2016, if this bill were in place, it would have kicked the Libertarian Party off of the ballot. In 2018, it would not have. They got 25.6% of the vote in the 2018 election. It did already have the effect, not this bill, but the current law had the effect of kicking the Green Party off the ballot in 2016. They wouldn't have the ability to recover that in the last couple of elections, except through petition to get back on the ballot. They were not on the ballot this last cycle. So I guess the point I'm trying to make is you can set a number wherever you want it. The voters and the number of candidates in a statewide race are going to determine whether you reach that threshold by and large. So I'm just making the point that we can move it to 10, we could keep it at 5. You could move it all the way to 25% this last election cycle, and you wouldn't have achieved, if the goal is to keep the Libertarian Party off the ballot, you wouldn't have achieved that. Thank you.
Thank you. Chair calls Rebecca Congdon.
Chair, members, my name is Becca Congdon. I am speaking against HB 4416 on behalf of myself. I am pro-life. Do you think you know what political party I belong to? I actually subscribe to a consistent pro-life worldview, which means that along with abortion, I am against the death penalty, torture, and unending taxpayer-funded wars. Do you know now which party I belong to? I support the First Amendment, the right to free speech and freedom of religion. I believe this right ought to be protected, whether it looks like a businessman not using his business in a way that he finds incompatible with his faith, or a woman wearing a hijab to work. As a Christian, I value the freedom to practice my faith. However, I have also seen how even Christians can be perverted by power, and therefore I do not want to live in a theocracy. So I also support the separation of church and state. Who now should I be supporting? I am tired of defenseless people being gunned down in schools and churches, and every time my representatives try to limit Second Amendment rights, I see them creating more defenseless people who will be unable to prevent the next evil act that is to come. I believe all men, not just Americans, are created equal, and therefore I believe in the right of peaceful people to travel freely as long as they do not violate private property. The war on drugs in our country is a failure and has discriminated against many Americans, especially minorities and the poor, and so I call for the legalization of marijuana. Who now should I be supporting? Can you try to fit me into the left or the right box in this state? I am representative of the majority of Texans who no longer label themselves as Republicans or Democrats, because neither party rightly reflects my positions and values. The only purpose of this bill is to strip me and everyone like me of the chance of voting for someone who could truly represent us and represent our positions and values. If your positions and values cannot stand up to the challenge of a third party or an independent, you should be ashamed of your positions and values. Thank you very much.
Members, any questions? Thank you. Chair calls Whitney Bilye.
Thank you, Madam Chairman, for pronouncing my name correctly as well. Now more than, I'm Whitney Bilye. I actually am I serve on the Libertarian National Committee as a Region 7 representative. I represent 5 states, including Texas. I'm a resident in the Houston area, and I'm here today representing myself against this bill.
Thank you.
Now more than ever, the people have indicated that they want choice at the ballot box, and they're exercising those choices. And this is what is scary to you guys. You all, as Democrats and Republicans, would seek to cling to your political job security. But representative government isn't about you. It's about the people that you are supposed to be representing. And by actively engaging in voter oppression and by doubling the threshold for our candidates to get on the ballot by 100%, that is absolutely a First Amendment violation. And that seemed to be something that was important to Representative Swanson earlier today. And it would not stand up against constitutional challenge, as was already mentioned, and that's already been happening around the country. And why all of a sudden we want to concern ourselves with what other states are doing, I have no idea. So any author or sponsor or supporter of this bill, I would love to see you actually look into the camera or into the faces of any voters in this room and actually tell them that they do not deserve more than 2 choices on a ballot. That the only 2 choices they should have are the old party candidates who are responsible for basically all the things that are wrong with our government right now. And tell them that above all else, you represent your party, not voters, despite having campaigned on liberty values. HB 4416 simply seeks to silence the only voices that are right now encouraging old party candidates to resist party extremism. An example of this, which also is a correction to Representative Middleton's statement earlier about our candidates not being able to garner support. In 2016, one of our statewide candidates got the endorsement of all 6 major newspapers in Texas. All 6 of them, and was the only candidate actually qualified for a railroad commissioner. Yet he barely got above 5% because of extreme party voting. And this is what you guys want to keep in place. I consider that a huge conflict of interest. And this is a knee-jerk response to the recent election results. And this is an opportunity for you guys to grasp at continuing to concentrate power. I would love to know what stakeholders were actually consulted in the formation of this bill. And earlier we heard people talking about free and fair elections. That's not what this is. Republicans and Democrats would, if we were to eliminate third-party candidates off of our ballots, Republicans and Democrats would be fighting over that one vote above the 50% threshold. And the only way to do that is by continuing to battle each other with their mutually contradictory principles and completely ignoring and alienating any voters who actually might prefer a more reasonable and representative option. This is an undue burden that seeks to disenfranchise free thinkers and decrease voter participation overall. We like to consider, I know that Texans like to think that we're a whole other country, but the reality is we are still part of the United States. And Business Insider reported that the United States, in terms of quality of democracy, ranks 21 in the whole world out of democratic countries. And 21. And of the top 10, the minimum number of political parties you see on ballots is 4. 4. And most of those are over 6. Yet we consider ourselves to be a free country and a free state. I know we all believe that, right? So this is an example of how none of what you guys are doing, if you support this bill, has anything to do with voters. It has absolutely nothing to do with freedom. And if you're going to consider yourselves to be for liberty and for free and fair elections, then you will oppose this bill, and if nothing else, leave it as it is. Thank you.
Thank you. Chair calls Ed Johnson.
Ed Johnson, representing myself, and I'm for the bill, HB 4416. Being in Harris County with the longest ballot on record, and it's actually in the Guinness Book of World Records. We made it there. This last election, it was, I don't know, sometimes some people had 5 tabloid, that's 11, by 17 pages was their ballot size. So by just adding more and more parties to it makes it more unmanageable for the voter, at least in Harris County. I looked at percentages. It's kind of white noise. If you're 5%, that usually doesn't change a race. You almost have to make it up to the 10% area to change a race. So that's when you really become effective. So I would think anything in the 5% range is just kind of white noise on the deal. It's you got to get up a little higher before you actually make an impact on the ballot.
Questions, members? Thank you. Chair calls Mark Tippett.
Thank you, Madam Chair. My name is Mark Tippett. I am here speaking on behalf of myself as a voter to speak against HB 4416. Mr. Middleton, we are not Florida and we are not Georgia. We're Texas. We don't follow, we lead. Texas was built on the blood of dissenters, people like Austin, Houston, Fannin, and more people, great people, that you actually spit in the face of with this bill. I am opposed to this bill, or any bill that gives an advantage to one party and at a disadvantage of another ideology. That's what this bill does. It rights no wrong, it fixes no ailment, it saves no taxes. It is a simple bill that gives the two-party system the leg up on anybody else who wishes to speak out against it. This bill is clearly directed to stifle free speech, to stifle freedom of expression, to stifle freedom of association. It serves no other purpose but to give the two-party system the upper hand that you have enjoyed for so long. You do not like that with 5% we have been able to maintain ballot access. You state that we need to knock on doors and we need to walk miles. Let me assure you, Mr. Middleton, I've knocked on more doors and walked more miles than you can ever possibly dream of in your entire political career. I do not need to be preached about of grassroots efforts or knocking on doors or changing hearts and minds. All we ask is a fair shake. And every time we meet the thresholds that you throw at us, now you want to raise it. I once again ask, what right does this wrong? What wrong does this right? What benefit? What citizen? Where are the citizens, your constituents, with signs holding up there that are yelling, raise the limit? There are none. It is nothing but a violation of our right that is enshrined in our Constitution, the right to freedom of speech, the right to freedom of association. And may I remind you, Mr. Middleton, and all of the council, you all took an oath to defend and protect our Constitution and our rights against all enemies, both foreign and domestic, even if those enemies are you yourself. Thank you.
Questions? Thank you. Chair calls J.T. Edwards. J.T. Edwards. Chair calls Victor Hinojosa.
Thank you, Madam Chair. Thank you, members of the committee. My name is Victor Hinojosa. I am the membership coordinator of the Libertarian Party of Texas. I'm here to speak on behalf of the Libertarian Party of Texas against House Bill 4416. We've heard great testimony. I'm just going to try to keep this very brief and simple. One of the greatest celebrated liberties of being a citizen in this country is being a part of a diverse melting pot full of many diverse ideological ideals and beliefs. That makes each individual Texan special and unique in their own way. Many of the members on this committee would agree with that. If not, I would gladly accept your resignation letter now. However, if we do agree with this statement, so then it should also make sense that we should also reflect how we love this diverse ideological differences with all these individual Texans. We should reflect that by allowing the members to have more options at the ballot if we believe in this. House Bill 4416 is another attempt to silence those diverse options for the voters, and what House Bill 4416 does is forcibly limit the options for the voters of Texas to strictly make them vote for either Democrat or Republican. This bill forces them to be blindsided by the current two-party system and instead places the illusion that this country is only limited to just those individuals who classify themselves with the capital D and a capital R next to their name. And I'm here to tell all of you that's not true. Not only that, but by raising the minimum requirement of ballot access to 10%, you are essentially telling all Texans voters who share nothing in common with the Democrats or the Republicans that all we are going to do is make it near impossible for you to ever have a chance to fully express the way you feel at the voter box. I've expressed to the members of this committee to please not allow this bill to move forward. Kill it now. I would not be opposed to that. Just throw it into the fire. I have a lighter in my pocket. Let's do it now. But let's go ahead and just appreciate the integrity of just the melting pot and this cultural diverse mix of people that we have in Texas. And I ask that you guys please allow us to continue having our options at the ballot. Thank you.
Questions, members? Thank you. Thank you. Chair calls Amy Lyons.
Madam Chair and members, I am testifying in opposition to this bill on behalf of myself. I'm Amy Lyons. In the Declaration of Independence, Thomas Jefferson wrote, "Governments are instituted among men, deriving their just powers from the consent of the governed. Do the governed not have the right to express their consent to the person they find most closely aligns with their political ideologies? Why do you seek to restrict rather than improve voter choice? This bill seeks to eliminate the voice of a growing population of constituents who choose to vote based on principle over party affiliation. Most individuals prefer more choices to closely represent their political values, but this seeks to destroy the core of liberty and freedom and choice in the political process as our founders intended. Third parties already face many disadvantages in election season from the beginning, with two-party system media biases. I ran for state senate in this previous election, and I received 10,500 votes, and I worked my behind off to get every single one of those votes. I had booths at local events. I knocked on doors. I went to other towns to meet individuals. To be discredited, stating that I did not do my work to reach out to these voters, is insulting. The previous election, our Libertarian candidate received 6,595 votes. I increased the voter number to 10,500. While that's a small increase, I do find that to be a positive change in showing people they have choices. Please reconsider this bill and get rid of it today. Thank you.
Representative Swanson.
I have questions for the witness. I was just curious as to what Senate district you ran in and what your percentage was and what the percentage was from 2 years ago.
Yeah, so I was in Senate District 5 against Charles Shortner and Meg Walsh, and my percentage was maintained due to a massive increase in voter turnout. I will say that in the campaign, I received many inquiries from people who had never really been involved in the voting process before, and they were looking at their ballot and they were going, okay, I want to know where this person stands on XYZ issue that's important to me. And I responded to each one of those emails personally. I made sure they were informed, and I will say confidently that I don't think that percentage would have been maintained had I not done all the outreach I did.
Okay, I didn't catch what percentage that was.
It was 3.2%.
Okay, thank you.
Any other questions, members? Thank you.
Thank you.
Chair calls J.T. Edwards. Is J.T. Edwards here? Okay. Members, I have Christina Atkins with the Texas Secretary of State's office. Does anyone have any questions for her? Do we need to call her up? Okay, thank you. Is there anyone else wishing to testify on, for, or against House Bill 4416? Chair recognizes Representative Middleton to close.
Thank you, Madam Chairman, members. I ask the committee for its favorable consideration for House Bill 4416. And with that, I close.
If there's no objections, House Bill 4416 will be left pending. The chair hears no objections. House Bill 4416 is left pending without objection.
The chair lays out House Bill 4255 and recognizes Representative Click to explain the bill.
Thank you, Mr. Vice Chair. As presiding officer of a county executive committee, the county chair has a fiduciary responsibility to turn over local party bank accounts to a new and incoming county chair. Failure to turn over local bank accounts to the new incoming chair within 30 days of the new chair taking office is a Class C misdemeanor per Section 171.028 of the Election Code. House Bill 4255 ensures county chairs have the authority necessary to perform their statutory duties and avoid the offense of a Class C misdemeanor. I did receive agreed-to language yesterday afternoon and have submitted it to Ledge Council for substitution, as it will remove the primary signer language and clarify that this applies to primary and corporate bank accounts. I'm open for questions and reserve the right to close.
Members, are there any questions for Chairwoman Click? Seeing none, the chair calls Kathy Hagler Please state your name, who you represent, and your position on the bill. Also, audience members, please be aware that we will be timing your testimony to 3 minutes per speaker. 3 minutes per speaker. Thank you.
Hello, I'm Kathy Hagler. I'm testifying for House Bill 4255. I'm representing myself. There's obviously some county parties who have infighting and they don't agree with each other. I'm grateful that my county party is not one of those. But for those where the majority of the county executive committee are trying to remove all the duties and authority from their duly elected or appointed county chair by adopting rules to keep the county chair from being a signer on the party's financial accounts or not have access to the party's financial records, that's just plain wrong. I've seen a miscommunication on this bill in my inbox that says it gives banking control only to the county chair without CEC oversight. I do not read that in this bill. It does not prevent additional signers. It merely keeps the county chair from being shut out. As a matter of fact, in our training, Secretary of State suggests that you always have at least 2 signers on every account. So if something happens to someone, you're not left out in the cold. And I fully support every county chair having signing authority on their bank accounts.
Thank you, Member Chair Click.
Ms. Hagler, is it not true that the Texas Ethics Commission holds the county chair responsible on that corporate filing? They're the ones.
The county chair alone is the only person responsible for filing that.
So even if there is a treasurer for the party, you
Yes,
are
ma'am.
still the one that suffer
I'm
the consequences.
responsible for that account, and we do have our treasurer as a signer just in case something happens to me.
And what would happen in the event that you could not see those banking records? It would be difficult to.
It could be run amok, and I would be responsible for it.
So could you actually complete that filing?
I could not. As a matter of fact, I know of another county party that exactly that happened. They excluded her from the bank account records. She couldn't get in online to file records and was not able to complete her primary report because she couldn't get access to the records.
Now, on your primary account, any of the checks that would come to the local party, say from Secretary of State, who were those addressed to?
To the county chair.
Okay.
Yes.
And so you, as the county chair, are accountable for how those funds are spent. Is that correct?
Yes, ma'am, I am. And I answer to Secretary of State for her reporting.
And, are there not guidelines as to how that money is to be
Very
spent?
strict guidelines, yes, ma'am, very clear.
And in your capacity of county chair, do you ever have to sign payroll checks in
I do.
relationship to the primary?
Yes, ma'am, I do. I do all the payroll checks.
And is it still the case that the county chair has to be one of the signers on those payroll checks?
I don't know the law on that. I just know that I am the signer.
Okay.
I plead the fifth.
Okay. Thank you very much for being here today.
Yes, ma'am. Thank you.
Any other questions, members? Chair calls Eric Opiela.
Having a hard to pronounce name doesn't stop anybody from coming. Thank you very much, Vice Chairman Cortez. Eric Opiela here in support of Chairman Click's bill, House Bill 4255. This bill clarifies that county chairs have authority over and are the primary signer on local bank accounts. As was pointed out in the questioning of Chairman Hagler by Chairman Click, Title 15 of the Election Code makes county chairs legally responsible for reporting in compliance with campaign finance law, yet current law does not clarify that they have signing authority over those accounts. Title 10 of the Election Code and Secretary of State rules also make county chairs responsible for all the primary funds, and they have criminal penalties if they misuse those funds or misappropriate those funds. To the extent that there have been any abuses of funds by county chairs in the past, these cases have been effectively prosecuted and resolved under Titles 10 and 15 of the Texas Election Code and other applicable criminal statutes. There's absolutely no reason that you would keep the county chairs off of an account that by law they're required to report make reports under the law and be accountable for under Title 10 and Title 15. And so I'm in support of House Bill 4255.
Thank you. Members, any questions? Thank you. Chair calls David Covey. David Covey going once, twice. Moving on. Chair calls Reagan Reed.
Madam Chair, members, thanks for your service to the state. I'm Reagan Reed, the Vice Chairman of the Montgomery County Republican Party, speaking on behalf of the party, and I'm speaking against the bill as it's currently worded. However, I signed up as neutral because if the substitute goes through, I wouldn't necessarily be opposed, because I don't think anyone opposes the county chair being the signatory on the primary
one second, please.
account. The issue.
So, sir, to be clear, what is your position on the bill before us right now?
As it currently exists, opposed.
Thank you.
And
So we're going to direct the committee clerk right now to change you from neutral to against.
Okay. My concern is with the wording of all accounts. The primary account's not an issue. That's part of their duty. But the issue I have with them controlling all accounts can be summed up in two words, and that's Rob Morrow. This was a gentleman who got elected here in Travis County. If you know anything about it, he would go to events with the big sign saying that Trump is a child rapist. He wore a court jester's hat to his swearing in. This is not a gentleman that I don't think anyone wanted handling and having primary signatory authority over the party's accounts. And so there needs to be a way for the county executive committees to protect the party's assets from these rogue chairmen that could get into office. And the concern is also that the money doesn't belong to solely the county chair. The money is given to the party, and the county executive committee is the primary governing body of the party, which is the precinct chairs and the county chair. And so to give sole power to the county chair to be on all these accounts, especially if it's a rogue chair, that upsets the checks and balances. And this is something that the government should not be involved regulating how we structure our accounts for the private donations that we receive. That should be up to the individual parties as private associations to adopt bylaws and structure that how they wish. And so those are my concerns with the bill as written. However, as I said, if it's amended to just include the primary account, I don't think that I would have an issue with that, but the bill as written just consolidates too much power in the hands of the county chair, and I would like to conclude with the words of Ronald Reagan, who once said that consolidated power is the enemy of liberty. Thank you.
Thank you. Representative Swanson.
Sorry to interrupt your applause there. Thank you, Vice Chairman Cortez. Mr. Reed, what I wanted you to address was what did you think about the corporate account? Because this is what I'm hearing, that any possible committee sub might involve the primary account, which you mentioned your idea about that, but also a corporate account. And I don't know much about that. And what would your standing be on that issue?
I would have to say I would be opposed to a law mandating that the chairman be a signatory on the corporate account because it's different from the primary account. It's dealing with the state law and their duty administering the election. With the corporate account, it's similar to the general account in that it's discretionary as to some extent what they're going to raise and what they're going to spend. It's from private donations. And so I don't feel that it's the government's place to get involved mandating how we structure our accounts or who we put on as signatories on our accounts. It's not an issue for us in Montgomery County because we don't really have any money in the corporate account, but just on principle of limited government, I would be opposed to that.
Any other questions, members? Thank you very much.
Thank you.
Chair calls David Smith.
My name's Dave Smith. I'm from the Montgomery County, the Woodlands, and I'm here to speak against the bill today.
And who are you representing, sir?
I'm representing myself.
Thank you.
You know, for the past 6 months or so, I've watched the members of the CEC work very hard to raise funds for the general account to support the upcoming election. Our county chairman has had no involvement in that process, doesn't attend the meetings, doesn't participate. And, you know, here today we're talking about turning over those funds to a gentleman who really doesn't participate. And, you know, I can see that being upsetting to a lot of people. You know, we have an account that the state administers, and, you know, he has control over that account. Over the last 6 months, we have a treasurer. I've never seen him present an accounting of that account. It's like he has personal control with no oversight. I mean, I personally know that Mr. Dickey has had a very difficult time controlling this man. And now we're going to hand over all these accounts to him. And I think that's, it's improper. You know, we've raised the funds without state oversight. And the people should have the right to spend those funds with the oversight of the people who raised them, and not the state of Texas.
Thank you. So, Mr. Smith, we have you signed up as on the bill. For clarification, you're saying you're against the bill?
I thought I signed up as neutral.
Yes.
That's correct, but you stated at the beginning of your testimony you were against.
Without amendment.
Today's bill you're against. Okay, I'm going to direct the clerk to change that officially.
Okay. Thank you.
Any questions for him, members? Thank you for your testimony, Mr. Smith. Chair calls Adrian Kaiser.
Mr. Vice Chairman, members of the committee, thank you for letting me speak today. I am Adrian Kaiser. I'm a member of the Montgomery County Republican Party Steering Committee, and I'm here representing that committee, and I'm here to speak against the bill. And I know I was signed up to be neutral, but I'm against the bill as it currently stands.
So two things. I need to change that position, and he says that he signed up to represent himself.
Okay, so we have you registered to represent yourself and that you're
change.
neutral. So we're going to change that to representing which group again?
The Montgomery County Republican Party Steering Committee.
Republican Party. Okay, and then we're also going to change your position on the bill to against.
Yes, sir.
Are we good, committee clerk?
He'll have to talk to her again afterwards.
If you could please visit with her right after so we can get that officially typed in.
Yes, sir.
Please continue your testimony.
So, in regards to the account, we've had a lot of problems with our current county chairman, as some of my other members have stated. And just giving him control of all accounts would mean he can do what he wants without any oversight. I feel that we are Republicans, as I said, so we should be against government overreach, and I feel that passing this bill, HB 4255, is the legislator getting involved in local party affairs. And I think local party affairs should be, as I say, to the local party. So I speak opposition against this bill on the sole basis that legislators shouldn't be dictating local parties and how they're run.
Okay, members. Chair Click.
Do you also feel that way about the primary funds that are directed to the party chair?
The primary funds are dictated by state law under
That's
what they
correct.
should, so they should be, that is something this chairman should still be in charge of.
And the corporate account, which they also solely are responsible for?
I'd have to do a little more on the corporate account just because I'm not as familiar with the corporate account as I am the general and primary.
Well, it's a campaign finance account and report that the chair is solely responsible for.
The corporate account, is what you're saying?
And if they do not file timely reports, they are the only ones, irregardless of who the treasurer is, that's penalized for that.
I don't know much about the corporate account. I'm saying
Right.
what I know. So
Yeah, there are times when you have a changeover in chair, and those chairs are not turning over that information. In my county, a number of years ago, it took months to get access to bank accounts. There were personnel to be paid, internet accounts, getting access to the website for the local party. This is pretty limited just to some of the financial. In the substitute, it is specifically the primary accounts and the corporate accounts.
well, if the substitute goes through, I'd be more willing to speak for it. But as it stands right now, I'm against as it currently is stated.
Okay.
Thank you, Madam Chair. Any other questions, members? Thank you very much. Chair calls Jack Barcroft.
Mr. Vice Chair, members, I am Jack Barcroft, and I'm speaking for HB 4255 on behalf of myself. I am still County Chairman of Coryell County, a member of the State Republican Executive Committee, and the President of the Texas Republican County Chairmen's Association, of which I love the most because I get to work with colleagues across the state that share my pain and share my vision. I do want to note that in the substitute I wanted a pay raise for the county chairs, but it just didn't make it. Listen, Election Code 171.028 talks about transition from an old county chair to a new county chair, in which they have 30 days to transfer all the assets of the party from the old chair to the new chair, including party records, bank accounts, of which the chair has authority of, et cetera, et cetera. And if they don't, there's a Class C misdemeanor that can be used against them, right? So, you know, I joke with my colleagues that we don't have a lot of financial upside to being a county chair, but at least we can go to jail if we forget to cross a T or dot an I. All right? Now, the statute today doesn't mention anything about steering committees, handing anything over, transitioning anything. It all talks about the county chair. So in 99% of the counties in the state of Texas, what we're proposing is status quo. This is crystallizing or elevating status quo to writing for purposes of clarity. I think it's actually a great housekeeping measure because in a transition, one wouldn't need to go research, well, which committee has what bank account, where are those funds, et cetera, who's the signer, who's the co-signer. It would be transitioned over in one clean batch. And I hope that the fact that this is the way it is in 99% of the counties in the state of Texas is considered by the committee.
Thank you. Members, any questions? Thank you, sir. Kelly Cook.
Hello, good afternoon. My name is Kelly Cook, and I'm representing myself, and I'm opposed to HB 4255. I currently serve as the Finance Fundraising Chair for the Montgomery County Republican Party, and this bill has the potential to make it more difficult for the Finance Committee to raise funds, I do believe. I do appreciate the committee substitute. I believe it brings improvements over the original bill, but I'm not sure it goes far enough to protect current local party structure. Allowing the county chair to usurp the bylaws adopted by the county executive committee removes the check and balance that most of us value. I am not opposed to the clarification of the chair being the authority on the primary account. I was considering changing my position to on upon hearing the committee substitute. But I think I'll stick with against at this point because I'm not really sure what the original intent of the bill was, and I'm still have some concerns over the corporate account. I really haven't had time to study it. I totally understand the primary account. I'm good with that, and I do appreciate your efforts when you removed all bank accounts because that would have really hindered my committee's task of raising funds. So thank you.
Any questions, members? Thank you, ma'am.
Okay.
Chair calls Glenn Maxey.
Thank you. I'm Glenn Maxey with the Texas Democratic Party. I think I registered on the bill.
Neutral, yes.
I would like to change it to for the bill. I appreciate the committee substitute. My original statement of being on the bill was just to point out the problems of both Robert Morrow and Travis County and the situation of in the past, our perennial problem of Lyndon LaRouche candidates in the Democratic Party. Harris County elected a Lyndon LaRouche person who had a great ballot name a decade or so ago, or maybe 2 decades ago, and those are party accounts that had millions of dollars and the party had to take the account away from the chair. If there was a way in this bill to also add one other thing, I don't know how we would structure it, but the whole thing about transferring accounts after there's a change in chairs, it seems to me that I spend most of my time after primaries of working with county chairs where the old county chair has moved away, has become unresponsive, or just refuses to participate because they got beat or they're upset with the fact of who the new chair is. If there was a way with a document from the state party that we could tell a bank that they shall transfer an account with correct documentation, in those situations, it would solve a lot of problems. Because while there's a penalty for not doing it within 30 days, we are fighting that battle with dozens upon dozens of county chairs every 2 years when there's a transition.
Thank you. Members, any questions? Chair calls, we have a resource witness here, members, Christina Atkins, if any of y'all have questions for her. Well, you haven't come up today at all, have you? Light day at the office. That's Joe's other ones, but okay. Chair calls Leah Allison.
Hello, my name is Leah Allison. I'm from HD16, and I'm against HB 4255.
You're testifying on behalf of yourself?
Yes. Okay. Well, I put self, but I'm also I'm the vice chair of Precinct 17, so I don't know if I'm just putting myself.
But you're testifying as yourself today?
Yes.
Okay, thank you.
So I'm from Montgomery County, and I've been seeing how a chairman intent on keeping control to the detriment of the local party, how that it can be a hindrance to moving forward. So we've had our bylaws changed so we could have more activity from the CEC members, and if the chairman was in control of everything. So that's why I'm against it, because the current wording says all of the accounts, and all of the hard work that the CEC members have done, I just don't see how it would be a good balance of power, because just in our American system we have checks and balances for a reason, so one person doesn't have complete control. So I just have concerns over the bill because of the things I've seen in my local party and just the politics down on the local level. So.
Thank you. Members, any questions? Thank you very much.
Thank you.
Chair calls Jeannie Stevenson.
Good afternoon, Madam Chair, members of the committee. Thank you for the opportunity to speak to you today. My name is Jenny Stevenson, and I'm from Conroe in Montgomery County. I'm speaking on behalf of myself. I serve in Montgomery County as a precinct chair. I'm here to speak in opposition to HB 4255. This bill attempts to control how our county party manages itself, specifically in the area of bank accounts. We have a duly elected county executive committee that passed bylaws just last June that clearly outlines who and how we want our funds to be managed. I believe that this bill unnecessarily intrudes on the sovereignty of our private party and the right of our executive committee to make our own decisions according to our bylaws and our rules for transparency. I would appreciate a no vote on this bill. Thank you.
Thank you. Members, any questions? Representative Israel.
Hi. Would you agree that there's a room here for the state of Texas to help the county party from time to time with some clarity when it comes to transition?
When it comes to transition, in our county, I think Mr. Reed spoke to this a while ago, our new bylaws that were passed last spring established a steering committee. And the steering committee is responsible for making decisions about how funds are going to be expended. And so I would like to let the steering committee and the county party work that out. I think there's room for the election code in a lot of different ways in managing elections in the state of Texas. But in terms of our internal issues like that, I would prefer to let our rules and our bylaws be in charge of that.
Thank you very much.
Thank you.
Thank you. Any other questions, members? Thank you, ma'am. Chair calls Alexei Swirsky.
My name is Alexei Swirsky. I am representing myself. I am for this bill, House Bill 4255. I am against this bill. I apologize. In the spirit of wisdom that a local entity knows better what its own needs are, I believe that each county party, both the Democrat and Republican Party and Libertarian, as we heard from that party earlier, need competing ideas to hash out what's best for our country, state, and county. Having the state of Texas dictate how a political party should be run on the county level is counter to the idea of discovering what works best through individual efforts, enhanced along the way by trial and error and learning from others. I appreciate Representative Click's wish to clarify what could be a confusing situation in regard to the deciding authority over a county political party's funds. However, financial control rules set by a large state government seem most likely to fulfill Thomas Sowell's prediction. According to the great economist Thomas Sowell, balanced budget requirements seem more likely to produce accounting ingenuity than generally balanced budget. I'm afraid with a blanket rule like this, there may be some hanky-panky and ingenuity involved in what occurs at the county level with this authority left solely with the county GOP chairman. Each party's county organization should be free to decide what is the best way to ensure honest handling of its money and to set its own standards for political and organizational structure in regards to that money. Please vote no on House Bill 4255.
Members, any questions? Thank you, ma'am. Chair calls Allison Winter.
Good morning, Mr. Vice Chair and members. My name is Allison Winter, and I am representing myself today, and I'm speaking in opposition of HB 4255. I am a member of the State Republican Executive Committee for SD4, and I'm also precinct chair for Precinct 59 in Montgomery County. I have become aware of being a member of the SREC of different counties who are having issues right now. And they're all varying issues, and they are different situations that are very difficult. And I can see how this bill could, if it passed, could really be harmful, because sometimes there's certain situations you can't prevent. I am a past accountant. I'm retired now, but in accounting, you learn generally accepted accounting principles with checks and balances. This is very important. And I think that we have an executive committee with elected officers in our county, and they create the checks and balances that we need. I do not think that a county chair should be in charge of all accounts where funds are held, and that it was just a recipe for disaster. And having these elected officers to oversee it is very, very helpful. So I ask for you to oppose House Bill 4255. Thank
Members,
you.
any questions? Thank you so much, ma'am. Chair calls J.T. Edwards.
Wow, just like a recurring theme. Mr. Vice Chairman, thank you very much, members. My name is J.T. Edwards, speaking on. I'm on, right? No.
No, we have you against.
Okay, against, yes. As it's presently configured. I'm sorry, it's just, I've had just a long day. So I am speaking against the bill as it's that's currently on the floor. However, hearing the
Who are you
upcoming
representing?
Galveston County Republican Party, I apologize. So,
thank you.
But the committee sub, that's very doable, and I think it's going to do a lot. Speaking from a voice of experience in Galveston County, we had a big, Donnybrook, as Representative Milton will tell you, that it actually ended up in the courts over these accounts. So having clarifying language in the election code goes a long ways to preventing some of these type of disputes. Galveston County is not the only one, Montgomery County and others. So one of the main things that we found out during the court proceedings is that the election code is unclear or there are gaps in guidance from the state. So we look forward to the committee substitute, and thank you very much for bringing this bill.
Members, any questions? Just to be clear, the committee substitute has not been laid out to the committee yet.
Thank you.
Thank you so much.
Thank you, Mr. Vice Chair.
Chair calls James Dickey.
Good morning, Mr. Vice Chair, members. My name is James Dickey, Chairman of the Republican Party of Texas. I'm here on behalf of the party, and I believe I registered to speak on the bill. Correct. Okay. So I'm just going to provide some information. The earlier Section 171.028 was mentioned about county chair transition. As a former county chair, I've been through a couple of these. Actually, I was elected twice as county chair, so I've been through this twice. That actually was an original part of the conversation about this. It's the part that makes it a Class C offense if the person fails to transfer records. When we started the conversation about all this, what for whatever reason none of us caught is that the very first part of that in A1 says what you get penalized for if you don't transfer is local party bank accounts over which the former county chair has authority. So what's good about my understanding of the substitute is that it just specifies the accounts over which a county chair must have authority and limits it to primary and corporate accounts. And the corporate account is based on that's based on secondhand information. I'm not positive about that, but again, speaking on the bill, some, not many, of our 254 counties have multiple bank accounts, and they do because there are federal funds which are limited to donations $10,000 or less per year per individual. There are plenty of our counties who don't get $10,000 total, much less $10,000 per individual, so they don't need then the separate state fund account, which allows for donations above $10,000 each per individual per year. And they don't need corporate accounts, which are only necessary if you accept corporate funds. And those corporate funds can't be spent during certain windows, and there are lots of limits around the corporate funds. Based on conversations, my understanding is that the corporate account must be controlled by the county chair, based on that other section of code. So to be clear, the proposed substitute, as I understand it, will all work together with this. The Class C only triggers on the accounts over which the former county chair has authority. This new substitute will specify the minimum accounts that a county chair must have authority over, that being the primary and corporate. So that's just me providing a lot of background on all of this.
Thank you. Members, any questions? Thank you very much.
Thank you.
Our last speaker registered to testify, Marcus Wooldridge.
Mr. Vice Chairman and committee members, my name is Marcus Wooldridge, Precinct Chair from Montgomery County. I'm speaking on behalf of myself, and I am against House Bill HB 4255. The election code already gives enough duties and authority to the county chairs, as already written. This bill gives control of the party bank accounts to the county chairman. This committee, should not involve themselves in this matter. It should remain in the hands of the local party. If a local party wants to give more authority to the local chair, they should be able to vote for it or against it amongst themselves. This decision should not be made for them by the state. Thank you.
Thank you. Members, any questions? Thank you very much, sir. Is there anyone else wishing to testify on, for, or against House Bill 4255? Seeing none, Chair recognizes Representative Clegg to close.
Thank you, and I close.
If there is no objection, House Bill 4255 will be left pending. Chair hears no objection. House Bill 4255 is left pending without objection. Members, that concludes our testimony for today. If there is no objection, The chair hears no objection. The Committee on Elections is now adjourned, subject to the call of the chair.